The adjourn. Just one second. 8 is at page 3. Vikas Chandra Parija for petitioner. The matter is listed under the heading fresh admission. And is mentioned for seeking adjournment. Accordingly, the matter shall be listed in the week commencing 11/5. In the week commencing 11/5. Listed for fresh admission in the week commencing 11/5. Attached to item 8. Yes, next.
Item 11. Item 11.
Page 2, item 4, 5.
Item 4, my lord.
4.
Train for 2 weeks time.
What up? Computer posting. Your name, sir?
S. Srichandran, my lord.
S. Srichandran for the petitioner. Well, matter was heard on 24/2/2026. After the allotted counsel was heard, whereas counsel for the petitioner was heard, he had adjournment to address the legal issue as noted in the said order. Again, the matter was adjourned and listed on 5/3/2026. Now, today the matter is listed under the heading fresh admission. The matter is mentioned seeking adjournment to grant further opportunity to the petitioner listed in the week commencing 11/5/2026. Yes.
Item 11 already.
Item 11, Mr. H.K. Mahanto for the petitioner. Mr. D.N. Lenka, additional government advocate for the state. The matter was heard at some length on 12/3/2026. The
The lordship
legal
directed.
issues have been noted. So, the allotted counsel for the petitioner mentions the matter seeking adjournment. Mentions the matter that is listed under the heading fresh admission seeking adjournment. Stop.
Item 2.
Accordingly, to grant further opportunity to the petitioner, the matter shall be listed in the week commencing 27/4. So, Mahan, the 27/4 11/5 कोर्ट है अपन.
ये 11/5
तो week commencing 11/5.
month.
My lord, item 2. Adjourn.
Two टा mention करा है sir. You are mentioning. Yes.
Page 4. Item 13 to item 16.
Item 14, kindly permitted to withdraw.
Your name, sir?
My name is Tia Vera.
ଆପଣ ସାଇନ୍ କରିଛନ୍ତି ये memo, withdrawal memo ଟା ଆପଣ କରିଛନ୍ତି. The order will be passed when it reaches.
Nice.
14. Yes.
Page 5. Item 17 and 18. Page 6. Item 94.
And item 24, kindly taken up after vacation. 24. 20.
Oh, sorry, 48. It after notice.
Yes, ma'am.
Other side will come but
Atish is my lord present.
40 टा के लिए अपन पोस्टिंग कर देवे. ऑर्डर किसी ना. पोस्टिंग कर जाए कंप्यूटर रे. हाँ. 40 टा करो तो week commencing reopening week the next week कले हबो.
Yes, yes.
Week commencing 29/6. At the past week टे छाड़ दियो. Week commencing 29/6. नॉले 6-7 है तापरे. Yes.
Page item 25 to 27.
one date टा note कर दीजिए again item 25 to 27
Page 8, item 28 to 33.
My lord, item number 33, kindly seeking for an adjournment.
33 केबे चाହୁଛନ୍ତି
My lord,
week ଅଛି मे ମାସରେ ନା ନାଇଁ ତାପରେ
my lord, may sir.
मे ମାସରେ
Yes, my lord.
list in the week commencing ଚାରି ପାଞ୍ଚ କେତେ ମ୍ୟାଟ ଲେଖିନା ଦେଇଛନ୍ତି ये वो 81 oh yes week commencing 11/5
Yes.
Item 29.
yes sir 29
Counter not filed. The other side will be
29 ବି ସେମିତି
29 40.
ଏ ମାସରେ ଯେତିକି ଅଛି ତାରି ଭିତରେ
18 ଦେଇଦେନ୍ତୁ we commencing.
week commencing 18/5
29 and 40 years.
just once
Number item number
29
30.
ଟା ହେଲା just
18
18/5 week commencing yes ଆପଣଙ୍କର କେତେ
item number 30 on behalf of
30 18/5 the other side inform
inform for the
ସେମାନେ ତିନିଟା ବେଳକୁ ଆସିକି
Yes, sir,
apply କରୁଛନ୍ତି।
Mr. Raut who
whoever can inform
ଆଜ୍ଞା ଆଉ interim order
after notice matter in their absence or your absence it cannot be taken up yes 30
interim order
entry order to touch simply posting ଆପଣଙ୍କର adjournment order ନା stay ଅଛି ନା କଣ ଅଛି
stay ଅଛି ନା
stay nobody is touching that it is only
published.
Page 9, item 34 to 39. Page 10,
40 ଟା କେବେ କହିଲେ ମହାନ୍ତି
18
18/5 40 18 then 41 to 43 43 Mr. Gochar
On behalf of my learned senior man, the pay for adjournment man.
other side could inform karibe
We have not informed him. I have not informed him.
inform karan
I'll inform.
because they will be yesterday almost at the last the hearing matter reached
Manage.
they will be waiting
Manage.
43 ଟା କେବେ ମେ ମାସରେ ନା ନାଇଁ
In, matter any day.
vacation ନା ନାଇଁ ମେ ମାସରେ
May must
ମେ ମାସରେ ତାହେଲେ week commencing 18/5
publish.
item 41 allotted.
41 yes
ଏକ୍ଜିକ୍ୟୁସନ ପ୍ରୋସିଡିଂ ଟା ଥିଲା 8/4/2026 ରେ ସେଥିରେ ଗୋଟେ ଅପୋଜିଟ ପାର୍ଟିର ଲଇନ ଗୋଟେ ପ୍ରପୋଜାଲ ଦେଇଛନ୍ତି ସେଟଲମେଣ୍ଟ ପାଇଁ
କରନ୍ତୁ
ସେଟା ଗୋଟେ ମାସ ଟାଇମ ଟେ
ମତେ
ମାଗୁଛି
participate କରନ୍ତୁ ହାଇକୋର୍ଟ କୁ participate କରନ୍ତୁ that is contrary to law ଆପଣ ଯଦି କଣ settlement କରିବେ go to the executing court and diyotu whatever it is between it is your choice actually
Yes, sir.
but don't make a high court in that process involve high court in that process
I want to adjourn this matter for
sorry
one month. There is possibility of settlement.
no I don't know whether there is an interim order I don't know
Yes, sir, Lordship.
interim order ଅଛି
Yes, sir, Lordship.
other side could
Okay.
କଣ ସେମିତି କଲେ କେମିତି ହବ behind their back don't take adjournment when it is a contested and there is a execution pending
Yes, sir, Lordship.
ଏମିତି କରନ୍ତୁ
Item number 90.
just 1 second ଆଉ ଥରେ ଯିବାକୁ ପଡିବ So Sharma 19 19 लिखिए शंभुचरण नाथ
Sharma.
I'm sorry I said Sharma but शंभुचरण नाथ शर्मा SC is a Nath Sharma S dot C dot Nath Sharma for the learned counsel for the petitioner refers to the order dated 3/2026 wherein after hearing the learned counsel legal propositions have been noted. He seeks further time to obtain instruction.
The file affidavit.
Whatever.
Hmm.
There is no direction for filing affidavit, so I have checked it. By mentioning the matter at the beginning of the day's proceeding. According to the matter shall be according to the matter shall be displayed in the meeting. 11/5 a week. The week commencing now 18/5. Just now I have crossed 60. 11/5 2026.
May I please your lordship?
Yes, please.
Your Lordship, writ petition number 1017 of 2026, Your Lordship. It was last listed on 26th of March 2026, Your Lordship.
You want a listing or a memo? You want?
Your Lordship.
File
I
your
mentioned,
memo.
Your Lordship, 1 minute, allow me 1 minute to submit, Your Lordship. This matter was last listed on 26th of March 2026.
Allowing you 1 minute or 1 hour doesn't make any sense. If you want listing, if you do not want listing, don't mention. If you want listing, then give memo. You have two choices.
Your Lordship.
Yes.
Your Lordship. Your
Yes.
Lordship.
Give your memo. Give your memo.
There is an issue, Your Lordship.
If you want it to be accepted in the court, request your learned colleague. He will file it here physically, or in the process from there you can file it.
Your Lordship. Your Lordship. Gratefully, Lord.
But I can't assure you the date. It will be adjusted. It will be adjusted.
Gratefully, Lord. Much of.
Item 1,
Item 1 was heard and that day who was appearing for state? Lincoln. First file ta dilo. अरे मग draft order टा करो. नहीं ऐसे तो नहीं कहीं. Draft order थी. वो बड़ा पहले नहीं आया on that date actually noticed after dictating the order
My lord, up to
that they are all D. diary
D
numbers.
number, my lord,
So then I inquired in the registry.
my lord.
I think the diary numbers are not being disposed of
Yes,
as
sir.
very. So then it took some time. I mean, I
Yes,
had
sir.
conferences with reputed
Oh, bless
with
you.
the registry. गाड़ी देना का पॉकेट जल्दी नहीं इतने नहीं अरे ऑर्डर नंबर मु खोजुनी से दिन जो ऑर्डर कराए थे लास्ट 6 तारीख दिन से ऑर्डर गाड़ी पॉकेट जल्दी तो अरे सिग्नेचर है नहीं जो ऑर्डर था ये चले चलती order number 1, order number 2, order number 3. The same order will be passed. Inform Mr. Only because now it has been registered.
registered.
Yes.
Order ta kali order ta कौन है ना? 6 तारीख order. कौन है लैंड?
Yes.
कौन जाएगी?
item 2,
Just one. Just wait. This is why Mr. Manta just wait.
Your Lordship, I'm for the petitioner. I'm on behalf of Niranjan Manda 1. Lordship, last order you have instructed to the senior counsel to take instruction for referring this matter to mediation.
You have Miss Majumdar.
No, sir.
कौन कौन है?
Ipsita Pani. I'm on behalf of Niranjan Panda 1.
Ms. Ipsita Pani on behalf of Niranjan Panda Ashwal. Mr. Gochat,
Minors.
any instruction or you
Minors,
want?
we have not received yet, minors.
The counsel for the petitioner refers to the order dated appearance actually. Opposite party likhibe Mr.
Minor, I am appealing SS Kashyap, learned senior panel counsel.
Mr. Deepak Gochat on behalf of Mr. S.S. Kashyap, senior panel counsel for R2. Mr. P.K. Mohanty for R1. जाके गवर्नर को डाल पाई भी नहीं मैंने बारीक हो भी ना के This for
My lord. My lord. List is-
city common wrongs.
Yes, right. My lord.
So that will take care.
My lord. My lord, putting LN number.
Because you.
Yes. Yes, your lords, lordship. I am just filing.
The additional standing. It is noticed that appeal is registered by number. The 55. Has further to be noted that the matter has to be taken up after it is registered as member. The purported reason for registering the matter with the direct number is as per High Court that AW is not the current nomenclature. Earlier the matter, signature was aware of. Earlier the matter was taken up on 24/2026, the current council for the was heard and order was passed by this place taking over the stand. LW not be the correct nomenclature. The matter shall be registered as and shall be registered as getting from 2 to 6. So this is that order. Now was the order as it is.
Yes, sir.
Like the post field does.
Yes, sir.
Check the party.
Yes. Yes, sir. I am. Your lordship, there is a return of annexed, your lordship.
That order will. The order has not been passed.
Yes, sir.
The problem is that the matter was taken up. This kind of change of nomenclature. When is coming in with the office room, they will finding I. The directing for change of nomenclature, they get it. It is not diary.
Yes, sir.
शेयर पड़ेगा memorial number defect is wrong. 32026. R1 is represented by this has not been issued. The response to PW2 9. Who have opened up private responses. All appeals for the petitioner. For the appellant, not petitioner. Appellant. When the matter is filed. The one is present of the R1. So. That further opportunity to the appellant. That in the state of heading. So we commence. Copy of this order, copy of this state of these things and we implement it to the counsel for the appellant.
Item 5,
Is an option. The last objection when I directed the state opposition to obtain
Research for the petition. To 6. Have you received?
Yes, I have received the instruction that on 25 March 2026, the DO has requested the government to pledge funds. Already the amount has been sanctioned, only since this matter relates to 2003. So, at least 4 weeks.
Submitted by the received from the opposite party. The DO has already, the district education officer has already processed the matter. He has written to the government.
Yes.
Funds. Require funds. Funds. To the petitioner. These funds are the issue for instruction for the service. Is the matter is of some time is taken. Some time is required to calculate the amount. No point. This is for the board say. According to the matter center, it said it will be commencing. 11 week na
18 May.
the 5 se put a correct.
11th of last week.
Already it has crossed 50.
This is the last week in Lordship, so therefore further be.
Tapare it has.
Ye jone no 10-12 ଜଣଙ୍କର ପଇସା. Yes, sir. But you Lordship calling on 11th or 18th? Yes.
Positive hope.
Yes.
item 6,
6 of the same.
Same.
item 7,
Right.
7
is Passover. One Passover.
So
Right.
ଆପଣଙ୍କ ନାଁ କଣ ସାର୍?
M Pagal.
ଆପଣ କରୁନାହାନ୍ତି? ଆଉ ଜଣେ ବି ପାଗଳ ଥିଲେ ଆପଣ ବି କଣ ଏକା ଟାଇଟେଲରେ ଦି ଜଣ ଆପଣ ତ ପାଗଳ ନୁହନ୍ତି?
ଆଜ୍ଞା।
ମୃତ୍ୟୁଞ୍ଜୟ ତ?
ଆଜ୍ଞା।
ମତେ ଲାଗୁଛି ଆଉ ଜଣ ବୋଲି ମୁଁ ଜାଣିଛି। নো সেটা দিব ভিত্তিতে টাইপ এবং ଦେଇଦିଅ କଣ ଏମିତି ହଉଛନ୍ତି ଆରେ ଲିଷ୍ଟ ଅର୍ଡର ଶୁଭୁନି this is not it ଆପଣଙ୍କର ଏଟା ଅନ୍ ଅଛି ମୁଁ ତ ଏଟା ଅନ୍ କଲି ଆକ୍ଚୁଆଲି ଅଫ୍ କଲି ଏଟା କଣ ଚାପି ହେଇଗଲା yes
Item 9,
pass over
item 10,
Mr. Vijay Kumar Sahoo for the petitioner. Yes, Mr. Sahoo.
May I please all document? Well, in this case, the petitioner claim before lordship for direction for transfer of CP case filed by, in this case, the petitioner is the wife, my lord. If she pray before lordship for transfer.
How many cases she has filed against the husband?
My lord,
Cases wife has filed against the husband, according to your information?
only CP case to pending before the court of the judge family court.
She the husband file करछन.
My lord.
ଆପଣ କେତେଟା ଫାଇଲ କରିଛନ୍ତି wife on husband କଲା
Before the court of judge family court, Bhadrak, my lord, under CP case under section 9 of the Hindu Marriage Act.
husband has filed.
And all.
ଆପଣ 498
I have filed before the court of the judge Bhadrak, my lord. CP under section 9 of the Hindu Marriage Act. Husband has filed before the court of the Puri under section 13 of the Hindu Marriage Act. I have also
ଆପଣ
filed,
ନୋଟିସ ପାଇଲେ 13 ରେ ନୋଟିସ ପାଇଛନ୍ତି
my lord,
ପାଇଲା ପରେ 9 ଫାଇଲ କଲେ
my lord. Madam,
okay
madam,
so,
that's
so you
between
are
the,
saying that the husband has filed 13
my lord,
you have filed 9
my lord.
and 498 domestic violence जोड़ा फाइल करना है
No, my lord. No. I have also filed a CRP.
125 144 144 CRP
My lord, which is both are pending, my lord. With the judge family court Bhadrak, Puri, my
yes got the part
lord.
and learned counsel for the petitioner the petitioner wife is before this court seeking transfer of you take your seat I'll dictate down I'll take some time 2-3 minutes one like is before this court seeking transfer of the civil proceeding number 337 of 2025 pending before the learned judge family court Puri 2 learned judge family court Bhadrak it is submitted that it is submitted the CP before the learned judge family court Puri is filed the marriage under section 13 of the Hindu Marriage Act seeking divorce seeking divorce as the seeking divorce by dissolution of marriage solemnized between the petitioner and the opposite party on 11/5/2022 stuff. The para submitted by the learned counsel for the petitioner that the petitioner CP dash
Para 14, my lord.
number টা কোনটো
Para 14. CP number 94 of 2026.
CP number 94 2026 under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights before the learned judge family court Bhadrak stop it is also stated and submitted that the wife has filed petition seeking monthly maintenance under section 144 of BNSS now criminal proceeding no not criminal proceeding number as CR.P. number 57 of 2026 also pending before the learned judge family court stop It is submitted, the wife has health issues. ବାପାଙ୍କର health issue.
ବାପାଙ୍କର health issue
ଆଚ୍ଛା, ଛାଡ।
more than 200 kilometers distance ମାଇଲ no direct bus communication ମାଇଲ
ବର୍ତ୍ତମାନ ଆଜ୍ଞା ବସ୍ ଆଜ୍ଞା ପୁରୀ is connected with Volvo. ଆପଣଙ୍କ ପାଇଁ free. ଆପଣ ଏଇଗୁଡାକ ଭାବିଚିନ୍ତି କହିବେ ନା ଆଉ। ଆପଣଙ୍କର ଯୋଉଟା 1000 ଟଙ୍କା ୱେଷ୍ଟ ଓଡିଶାରୁ ଭଲଭୋରେ ଆପଣଙ୍କର ୱିମେନ୍ ଇଜ 300. କଣ no direct connection, but both are headquarters. Have you traveled in Volvo? It is, I mean, I think to your home also, I think Volvo is going from Puri. Puri, that is called, what is that? Sikhetra. Sri, that name is just some Sri, yeah. Not Lakshmi. Lakshmi is connecting to headquarters. But Puri is now connected. I mean, since long it is connected, for 2 years. The wife facing, submitted, the wife is facing difficulty. She stays in Bhadrak. As she difficulty to attend the matter at Puri. As she is staying with her parents at Bhadrak. After her marriage, rock weather. So far. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 7 working days. Within 7 working days, a returnable date be fixed to 11/5/2024. The matter shall be listed in the week commencing 18/5/2024. Stop. List after SR, liberty to mention. Therefore, the listing date is date is fixed. Then IA 101 of 2026. Hard Learned Counsel for the petitioner, he reiterates his submissions as noted above. He seeks for stay of further proceeding in the CP 337 of 2025, pending before the Learned Judge Family Court, Puri. Stop. Issue notice as above. Accept one set of process fee as well as postal requisites along with the petition. Along with the petition. The returnable date and the next date of listing shall be as directed above. Stop. Stop. In the interim, it is directed. The further, the Learned Judge Family Court, Puri shall adjourn the CP number 357/2025 to a date beyond 25/5/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the state purpose. Yes.
Item 12.
Item 12, my lord, here the during pending the present date petition.
Yes. So Dipti Ranjan Mahapatra for the petitioner.
In view of the amendment brought in 2021, since the issue which involved here had to be decided before the competent civil court, and we have filed a suit bearing 650 of 2023. So, Your Lordship, I pray this petition be withdrawn with a limited direction for early disposal of
early disposal. Constitution bench. You should not. Constitution bench has taken strong except directive. Allahabad Bar Association, where the Asian resurfacing has been visited. 43.
Yes, sir.
That is not.
This reapplication has already become.
That Your Lordship, I think there is to note also.
Yes.
In the
paragraph 2 of Your Lordship's order.
Yes.
Not 92/2000.
Many further.
Mr. Dipti Ranjan Mahapatra for the petitioner. Mr. T.N. Lenka, additional government advocate for the OP number 1. Mr. Samin Mr. advocate along with Mr.
Sir Behra.
S.R. Behra for OP number 2.
May I just humbly clarify?
That
I am for the intervener, not for the OP number two.
Mr. Vishnu for the intervener. In IA number 18220,
My 2025.
the intervener in IA number 1822025. Seeking intervention in the writ application. So it is since he's withdrawing, I have not observed anything on.
No,
I need not.
I am
Apna
only-
memo de diyo.
Your lordship is
Memo
only
de diyo. Yes.
recording our presence, that's all.
Yes, yes. The
In fact, there was a suit which they lost and it is pending in the shape of an
The learned counsel for the petitioner files memo of date which indicates thus. The memo shall be taken on record, scanned copy be updated. The learned AGA as well as the learned senior counsel acting for the intervener are present and reiterate their submissions as noted in earlier orders dated 15/1/2026, 9/2/2026, 18/3/2026. Stop. In view of the above, the writ petition is disposed of.
It's not report.
Shall I observe? I'm not, it's only a suggestion, I'm not directing that you will cooperate, parties shall cooperate.
Yes, sir.
Where my
Before in the appeal.
My appellate court ପାଇଁ ସେ ଗୋଟେ order already ଦେଇଛନ୍ତି, ସେଠି I have filed a
No, no.
petition for recall.
In connection with this
Achha.
particular
So,
issue.
ସେ
the
recall
suit
କାହିଁ
is-
file
So at times
କରିଛି
it gets complicated.
ନା notice sufficient ହେଇନି.
For
that
that
is-
reason,
ନାଇଁ, I'm pointing out କାହିଁ
ethics court
ହବନି
has said that.
ନା order 5 rule 20 ରେ notice publish ହବା ପାଇଁ order ହେଇଛି, notice ଏପର୍ଯ୍ୟନ୍ତ sufficient ହେଇନି, appeal is not complete for hearing.
That has taken note of by the Supreme Court. That the court who is in season of the matter,
ଆଜ୍ଞା
that's in the best position to decide what to
ତାପରେ
do.
ଗୋଟେ parallel direction ହେଇକି ସେଥିରେ
Constitutional
modification pending.
like this.
Modification filed by me is pending. ଆପଣ
Here
କହିଲେ
the-
that will possibly overlap.
The present, in connection with the present dispute, the suit is pending. I'm sorry, my lord, the suit is pending.
Whatever.
My lord, it is false to say that the suit
order,
is dismissed.
you must read that, in fact, Justice, there is there is a parallel opinion, short opinion. It is observed by the Honorable Supreme Court that Justice Mithal, that at times in the, while intending to do justice, we do injustice. Fixing of this time limit, yes. Actually it gets complicated.
That's correct. I am
No,
not
no.
praying for anything for
No, no.
the time
Leave
limit.
it there.
That,
Whatever,
whatever lordship to observe
sir, the
that
CPC is very clear.
cooperation.
Sir, here the CPC
We
is
should
very
cooperate.
clear when the appellant is present, respondent not present. Respondent is present, appellant not
ସିଏ
present.
କହିଲେ suit dismiss ହେଇନି, annex C/3 page 31 ସସ୍ମିତା ନନ୍ଦ ଏଠି ଯିଏ ସେଇ ଅଛନ୍ତି ସେଥିରେ plaintiff, your lordship may see page
Suit number
188.
is
ତାପରେ
650 of
କହିବେ
2023, man.
Taper
650 of 2023.
So this saga will continue.
Yes.
Therefore,
So
650, 2023, that is still pending.
the writ petition is disposed of.
Yes, sir.
It is disposed of.
Minus only
Yes,
thing
next.
that I am withdrawing because I have filed a suit bearing.
Whatever you write your memo, that
Yes.
will be a part of the.
Yes,
that
yes,
will be recorded.
My lord, my
only ଖାଲି liberty ନ ରହୁ, liberty
See, ସେଥିରେ, it is disposed
create
of.
further wings.
Item 13,
Obliged.
Pass over कर दियो. Pass over भी कर दियो.
item 14,
दियो, memo टा दियो. On 17/3/2026, the following order was passed. Quote कर देना. The appearance लिखी हुई Mr. P.R. Behera for the petitioner. Opposite party blank. अपन लिखी हुई on so and so date the past. The matter being in the list is mentioned at the beginning of the day's proceeding. It is a memo of date. Memo of date is filed by the learned counsel for the petitioner, which states thus. Quote कर देना. The memo shall be take quotation SIC लिखी हुई to back. The memo is taken on record, scanned copy be updated. In view of the above, the petition is disposed of. Stop. Copy of this order shall be forwarded to the learned judge, Family Court Bargad, to be kept in the records of CMC number 28C.M.C. number 28 of 2021.
Item 15.
May I plead your lordship?
Yes.
Well, I have an IA. Saying lordship to exercise lordship's power under section 340. Plus item 15 and item 17.
Yes.
Both are connected plus.
Yes.
And in item 17, the lordship has already directed by order 10/10/2025. Sir, my lordship can take up item 17 so that.
First, let us go through 15.
Yes.
10/10.
Item 17, 10/10/2025, your lordship has passed an order.
नहीं 15 तक होता है.
15, that matter.
It is a disposed of application.
It's a disposed of application.
Yes.
But your lordship can see the order.
Item 15. I'm holding 15.
15.
15 ने को order.
6107/2023.
Yes. Which order?
The order by which bail petition has been disposed of.
10/23.
There your lordship will come to paragraph 3. Because some documents were filed which were false documents. That your lordship must have remembered. I'm reading that part. Thereafter, the London Council for the State was directed to obtain instruction in response to the IA. In obedience to the order of this court, London Standing Council produces a letter issued by the DSP UW Bhubaneswar by dear number so and so. The verification of the medical reports produced by the applicant annexed to the IA leads to a matter of concern as it is stated in the said report. Relevant portion of the report is quoted here in above. The Registrar Administration, SCB Medical College Hospital, Kotak, submitted the report by member number so and so dated 14/9/2023, which revealed that Mrs. Sonia Tripathi, wife of Rajiv Lochan Das, Bhubaneswar, has not attended obstetric and gynecology OPD, OGOPD on 25/7/2023 and on 29/7/2023. Moreover, signature of the assistant professor in the OPD card doesn't match with the signature of any of the assistant professor of 1G department. Hence, the petitioner has furnished the forged medical documents in the name of his wife, Sonia Tripathi, to get relief.
Yes.
Hence, has deliberately played fraud before the Hon'Ble Court. As the petitioner has not approved this Hon'Ble Court with clean hands, the petitioner is not entitled to any relief. Moreover, it appears that Sonia Tripathi, the wife of the petitioner, has shown the affidavit before the Hon'Ble Court. Hence, she has filed false affidavit.
This is the report you have.
And
para 4, read para 4.
London Standing Council, referring to the report, submit that such practice amounts to interference with the process of the court and is to be dealt with sternly to send a message to such person. And then was important is paragraph 7. Having had London Council for the petition, London Council for the information refers to and other earlier events when allegedly false/false documents have been filed by the petitioner accused for getting bail that has led to some proceeding before the Orissa Council. London Council for the petition IA number 145/2023 is also the London Council in the bail application. We submit that the petitioner herein doesn't want to pursue the IA and the same is to be withdrawn by the petitioner. Having had London Council for the petitioner applicant, London Standing Council for the State and learned senior advocate for the informant, this court is of the considered opinion that though it is a matter of concern, but considering the age of applicant, she being the wife of the petitioner accused in the BLAPL, who is in custody, a lenient view is to be taken and the matter is to be set at rest as of now. Here, just I want a modification in this case. My humble yes, section 340.
Of that this court becomes functus officio. Only arithmetic and
in the next matter,
reconsider on merit.
In the next matter, it is not on merit because
I cannot reconsider. My order, if it is to be challenged, it has to be challenged. But I cannot modify.
Plus, what has happened?
That Supreme Court decision is there.
Plus, there are also judgments. Plus, for a moment, what I am to bring to lawsuit can notice.
You have to say that after this court has, because that is the reason for noting that. Because it has been noted and considered, it can't be revisited. Mr. Katkia, you are vying for somebody's blood.
Yes.
That is, court will not assist you. You vie for the blood.
No, it is not like that.
So you are seeking that is completely contrary to law.
No, you will also see what by taking advantage of the order passed by Lordship, in the next application, in the other bail application, what ground he has stated that a lenient view is to be taken and the matter is to be addressed as of now. That is the ground they are taken in the next bail application.
Let the court quote that mistake which I have done.
No, it is not a mistake. I am not saying it is mistake.
I cannot guide. You must understand, Mr. You are a veteran.
Yes.
A petition every now and they take wrong pleas.
Yes.
It is for the court to accept that.
Yes.
As far as acceptance is concerned, and you see, you must understand, this is what you are reading, as if it is part of the order, it is a report.
Yes.
That person who has prepared the report, what is the veracity, what is the authenticity, even the court have gone by directing inquiry.
Yes.
So even that was left at rest. That is for the report also.
Yes.
Both things.
Yes.
I think you are too seasoned to understand that.
I have understood.
Because why such report is presented to the court?
Yes.
Why there? After day in, day out, the police personnel, they commit so many wrongs.
Minus.
But still, then how they are so concerned and how they are so motivated that they are upholding rule of law.
And appreciate my side. What has happened to me in this case?
You see, that aspect has not been. That has also been put to rest.
Yes.
Because by digging further, it is not. It's not that the other side is to be who has committed some allegedly.
Yes.
Because even if content matters also, then why opportunity is given? So that is another thing. It is a broader aspect.
Yes.
I am just discussing with you.
Yes.
But my powers are limited. You know that.
There, you has got absolute power even to initiate a criminal contempt.
So that I have considered in past order. Para 6 and 7. Para 7. Para 7 is whatever. That may be according to you is correct.
Has taken a compassionate view because that he is in custody. And
Mr. Katkia, you will be surprised in how many cases as a state counsel.
Yes.
I have produced the records before division benches. I can tell you, I still remember. So they are also I have learned it from the bench only.
Yes.
With my little practice in that side, criminal side, where I have defended, I have argued as a prosecutor, I have seen courts never taking exception. I have found out. Even I remember the judge name also. I have learned from them only.
Yes. There is a process
petition will be filed.
It is a process of
petition will be filed that so and so is having a gynec problem. The report is filed of somebody else.
Yes. I have also come
you are at the bar that side.
Yes.
Then why the learned division bench? They are very strict. They are very strict also.
Yes. But my humble shall be
so these every application filed on behalf of the petitioner who is in custody regarding the element of wife, at least thrice I have seen the wife is only made it is legal advice.
Yes.
filed by the court, filed in the court by the legal advice. I have seen myself in one case, Justice, the division bench, I think it has taken some note, but there are several instances where the court has just left it there.
In one case also,
because now the problem is, the other aspect is that if it is withdrawn, how do you say that the court was influenced?
No, it's not. It's not.
That is another problem. So it is withdrawn.
That is withdrawn.
But I don't remember the case number. Case number I don't remember, but these are the instances.
In one case also, I have seen in Rambapes and court has initiated proceeding against
Kota.
Yes.
I have Kota given the location, I remember.
Yes.
Bench, if you want, I'll tell you.
It's
a criminal appeal division bench.
But here,
so there, I mean, wife's ailment certificate and all these things. Is it that the court did a wrong? So that has, I have reflected on that, and I never said that the court may take a lenient view. As a lawyer, I never said that.
But here,
when you suppose you are appealing for the appellant,
yes,
medical certificate is produced. You even do not know even what is there.
Yes.
In division benches in criminal appeal, I have said that.
Here, the person who did this, not only have been defrauded, but also the way even my life has been put to peril because I have been informant.
Sir, I am not the court
assistant.
Please don't argue on merits of the case. You are vying for blood. You suck the blood or you take the blood, whatever, but don't bring the court.
And plus, you're on the other in the other matter.
Still remember the Bonkole audio. I mean, also these points are effectively argued by Mr. I can see Mr. Naik. These points were argued.
How much after I have come?
And I gave a thought over it also.
Yes, but that appears from your lordship's order.
I gave a thought over it. I gave a thought over it.
Your lordship's order is very clear on that. I leave it to your lordship's judicial constraints.
I8 code I8 almost.
IMLS 1099 by
1099 of 2025. The IA has been filed with the following prayer. But Mr. Janmejay Katakia for the item 15. Mr. Janmejay Katakia for the 40 KATI. Petitioner IA 1099. Opposite party, Mr. Assistant Standing Counsel, PK Manti. The Lorded Counsel for the petitioners admits that
I am for informant opinion.
Counsel to the petitioner in the IA. Petitioner in the IA. He now appears for the informant who was the opposite party in the disposed of ELPL that was disposed of order dated 5/10/2023.
Yes, please.
5/10/2023.
2023.
Yes, 2023. He refers to the disposal of IA number 1045 of 2023 along with the PL appeal. He submits that after disposal of the application, he has entered appearance on behalf of the government, filing occurrence with consent of the previous counsel. Stop. Counsel refers to the paragraph 3 to 8, 7 of the order. It passed in the IA 1045 of 2023, disposed of by order dated 5/23. The IA was filed. Seeking in this court under section 340 of the CRPC, the bracket since it and substituted by parameter provision contained in DNSS 2023. In the BL appeal 6107/2023, order of disposal was passed as it was withdrawn. Considering the prayer made in the IA, the present IA, by the informant, to consider the prayer made in the IA, this court has to revisit and reconsider its order passed in IA number 1045 of 2023. That was disposed of with the following observation at paragraph 7, which is reproduced here. Paragraph the section 362 of the Code of Criminal Procedure, 1973, to bracket since repealed and substituted. By section 403 of BNSS 2023, bracket closed, provides thus. It is CRPC applicable now.
CRPC. Occurrence has taken place prior.
Provides thus. 362 ta quote karibe. Court not to alter judgment. In the decision rendered by the Honorable Apex Court, this aspect has been elaborately dealt with. The decision that debate. In view of the above, in considered view of this court, the petition is not entertainable as it would amount to alter or review the final order disposing of the IA 1045 of 2023 by order dated 5/10/2023, along with BL APL number 6107 of 2023, out of which the IA arose, which was also disposed of by order dated 6/10/2023. The IA is disposed of accordingly. 17, what you are saying? 17 record
17 plus, thereby order dated 10/10/2025. Also can fill that order.
17.
Yes.
We have to wait.
Yes. The prayer was, similar prayer was made before the Supreme Court, and there the law was directed at paragraph 3. 10/25. The records of the BLF and the present IA shall be placed before the registered judiciary to furnish a prima facie report before the scope for consideration regarding the allegations made in the IA.
Yes.
So that report must have come. I think that is there.
The J Raju. Report is submitted in compliance of the order dated 10/10/2025. लिखिए IA नंबर टा काइंडली कॉल
19 of 23.
नहीं,
IA नंबर टा कितना
19
of 23.
IA 19 of 2025. IA has been filed in the disposed of BLAPL 7177 of 2024. Disposed of by order dated
22/11/24.
22/11/2024. Is submitted by Learned Counsel Mr. Kotikia, J. Kotikia, that he has appeared on behalf of the adjournment. Who was that? Say, appear करथिले BLAPL. A BLAPL informant appear करथिले. Who was also appearing in the BLAPL 7177 of 2024.
Yes.
Stop, no comma, by obtaining consent from the Learned Counsel who was appearing previously.
সেটা ফুলে উইথ লেখাই দিব, উইদাউট কনসার্ন লেখাই বাট দ্যাট ইজ উইথ কনসার্ন লাইক
এটা টাইপ করে
হ্যাঁ টাইপ
করে বাকি তো উইথ বিষয়টা অ্যাকচুয়ালি মার্ক করে উইথ লিখতে দিই
জাস্ট
আচ্ছা
পয়েন্ট আউট করে
রাইট ইউ আর রাইট The Learned Counsel then refers to the order dated order कितने पहले होता है
10/10/2025
10/10/2025 you are appearing
On behalf of Arun Kumar Accident, petitioner will be well
disposed of bill application. तब ऊपर लिखिए श्री सोहन सो सर नाट अपन आकर करेंगे सूर्यकांत द्विवेदी on behalf of के आचार्य Learned Counsel appearing for the petitioner in the disposed of bill application. ना भीतर लिख दो भीतर सेंटेंस का लिखिए होगा Mr. Additional Standing Counsel Additional Standing Counsel appears for state. Stop. By order dated 10/10/2025 in the IA 19 of 2025, the following was directed. Para 2 or 3. Pursuant to the said order, the learned district has placed for consideration of this court his report, which indicates the fact Jere Achi, being noticed the informant had appeared before undersigned and filed affidavit. So the product code Korea for you. Placed for kind consideration and order say. Apparently, before the register judicial, pursuant to the order of this court, the informant had appeared, filed affidavit, enclosing documents. Documents obtained through RTI have been annexed to his affidavit. Informant he na C. He. Affidavit. Tala. C. Sonia Tripathi. Informant. Regarding the allegations made in the affidavit in IA, order like the earlier matter.
Yes.
Order
No,
IA first time file.
Yes.
And IA dispose of
no, it
IA file dispose of IA for a file. Regarding allegations in the IA as well as the affidavit filed before the Lord Register Judicial, the following has been found. Quote. So if the charge sheet that happen already quote correction the scan so if the charge sheet along with the FIR and complaint petition filed are believed to neiki sesa pata hauchi seda any forum last aduko achi last ku dita choto paragraph achi ta upuru 5-10 lines. To find that, Mr. Kotak. Okay.
May I get a copy of this one?
No. So this is directed by the court. The same problem. The same problem that you are thinking that I am the sub-inspector investigating the matter. Inspector directed the Registrar Judicial is the sub-inspector or ASI because these matters ASI will investigate. Now ASI are so don't convert me so. Para. In view of the above, this court is not satisfied. It is file provision 340.
Same allegations in other bail applications. Same allegations were made by filing the exposed by the coordinate benches.
Obviously, এটা যেহেতু ମୁଁ ତ ସେଥିପାଇଁ ପଚାରୁଥିଲି ଯେ ଏଥିରେ ଆଗରୁ ବେଲ୍ ଆପ୍ଲିକେସନ ହେଇଥିଲା ଏଥିରେ ବେଲ୍ ଆପ୍ଲିକେସନ ୱିଥଡ୍ର ହେଇଯାଇଛି ଏଥିରେ ଆଇଏ ଫାଇଲ ହେଇଛି
ଏଥିରେ ସେଇ ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି because your lordship has said it has been stated
right than in the war also. Now you find the facts is stranger than fiction. जो war ବର୍ତ୍ତମାନ ହେଲା all of us are going through the shortage of energy shortage and entire world is suffering. It is more strange than that. ନା ସବୁଥିରେ ଅଲଗା ଅଲଗା ଓକିଲ ବି ଥିବେ. So that is the best. ସବୁ ଜିନିଷ ଆଜ୍ଞା ଠିକ ଠାକ ହେଲେ ଆଉ ଓକିଲ କଣ କରିବେ?
ନା ଏଥିରେ ପିଟିସନର କିଛି କହିବାର ନାହିଁ 340 my submitting whether to initiate a proceeding on 340 or not,
It is like
because he has to defend himself before the learned court below. If it is
right, but to initiate also, then that the court has to be satisfied. In view of the above, this court, the ingredients as contained in section 340 of the CRPC are not satisfied for directing any further action. So the idea is disclosed. Either coup matter, either can say medical. So medical, either I would matter.
Address.
Either I would address. ଆପଣ ସେ ଯୋଉ ଜଜମେଣ୍ଟଟା ଗୋଟେ କହୁଛନ୍ତି ଯୋଉଟା କୋର୍ଟ କନସିଡର କରିଛନ୍ତି କିଛି ରେଫରେନ୍ସ ସାଇଟେସନ ଦେଇଛନ୍ତି କି ତା ଜାଗାରେ ସେଟା ଦେଇ ଦେଇଥାନ୍ତି ସେଟା ଗୋଟେ ଆକୁ ବି ଦେଇ ଦେଇଥାନ୍ତି ମିଷ୍ଟର କଟିକିଆ ଆଚ୍ଛା ଆପଣଙ୍କର ସବମିଶନ କିଛି ଅଛି ସୁଡ ରେକର୍ଡ after hearing the learned counsel for the petitioner in the IA, the counsel appearing on behalf of the petitioner in the disposed of bail application is not asked to respond. से डिसीजन ना कौन मिस्टर कटिके जो 340 रे आपन मन पड़ 340 रे जोटा पंजाब स्टेट ऑफ पंजाब वर्सेस 340 को 362 रे
362 तो there is so many documents, of course I can get it and within
there is one
360 the statute itself is clear, very clear.
Balbir Singh Chauhan's judgment, I think so.
Yeah, there are so many judgments are there on 362. Because the court becomes functus officio after
there is a purpose behind this. Because why there is no such similar provision? Of course, CPC is there, but CPC I think it is not that explicit. CPC is there also. Court should not accept arbitrary and typographical error because it has to go for appeal, revision, review, whatever. Higher court, and that. Or if the court is having any power, then it's a different thing. So 362 denies that power. Correct. Thank you.
Item 16.
I'm providing the judgment. That judgment. Some Ranveer Singh, I think.
Yes. I was reading that in some context of some other year. Actually, that is how.
Lord, I am appearing for OP3, principal of Bali College. Lord, if I may submit.
Partnership and testing number on behalf of Subhash Chandra Achan.
Upon appear court section, sir.
I am Sahil Smarak Jati, associate of Dr. Mishra.
Mr. Agarji, what are you What's your name, madam?
Taskin Kamal.
Taskin.
Taskin Kamal.
I treat someone like my nephew. His name is Taskin, but you are saying your name is Taskin. He's a small kid. I don't know. Like Alok, I find is both. Miss Taskin Kamal.
Taskin Kamal.
Please write it. Taskin is a gender neutral name. Mr. Prem Kumar Mahanti. Mr. Mahanti, you are there?
Yes.
Mr. Prem Kumar Mahanti for OPs 1 and 2. Mr. S.S. Jati for OP number, along with Dr. Mishra. Dr. Vinod Kumar Mishra, along with Mr. S.S. Jati for OP number 3. So, you have received copies?
Yes, my lord.
You want to respond?
My lord,
or it will be restored? What is your any instruction? Or
no, instruction is that the medical, all the medical documents are prescription. the petitioner here is a teacher, so he doesn't have any idea about what the prescriptions are. And the petitioner of this case has retired in the year 2004. Now the present OP is the principal. He's been appointed in the last 2-3 years.
Sir, when you are holding an office, this plea cannot be taken. You must understand. Like, take example of Mr. Mahanti. Tomorrow, Mr. Behra is there. Next day, Mr. Lenka is there. Can they say that? So, office is like that.
No, not for the office, for the medical sake of medical documents. Because all the
No, I am not getting it actually, what you are saying.
But in the additional affidavit, the medical prescriptions are submitted relating the health issues of the petitioner.
So, I mean, the court is asking for your opinion on that.
No, but the submission instruction that I received is the petitioner is not the competent authority to examine the medical documents. If you
When the order has been passed, that I am asking you, which order by which you have been asked to examine that? By which order?
not any order instruction. Instruction.
Have you read CPC?
Yes, please.
So you can be a proper necessary party or a what is that called proper party. And are you saying that you are not a necessary or a proper party?
No, not necessary a proper party.
This is an application. Same APL is under a particular legal provision.
Yes,
you have been made as a opposite party number 3. So what has that to do with a medical prescription and a petition? Are you making a submission in context of the adjudication or in a general? You are saying that what the OP3 knows and because that's not being asked.
No, something.
ଆପଣ ଓଡିଆ ବୁଝୁଛନ୍ତି
ଆଜ୍ଞା
ଆରେ ଆପଣଙ୍କର ଗୋଟେ ପିଟିସନ ଫାଇଲ ହେଲା ଆପଣ ଯେତେବେଳେ ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର 3 ହେଲେ
ଆଜ୍ଞା
when the court issues you notice you will say that I am not a necessary party nor a proper party very well but ଆପଣ ମେଡିକାଲ ସାର୍ଟିଫିକେଟ କଥା କଣ କହୁଛନ୍ତି
objection ଫାଇଲ କରିବି ନାହିଁ objection କିଛି ଫାଇଲ କରିବୁନି
ତାହେଲେ ସେଟା ବି
as per instruction objection file କରିବା ପାଇଁ
କିଛି କହିନାହାନ୍ତି
ନାହିଁ
ଆଜ୍ଞା କିଛି ବୁଝି ପାରୁନାହାନ୍ତି ସେ ତାଙ୍କର କଣ କୋଉ ସବଜେକ୍ଟ ପଢିଛନ୍ତି
ନାଇଁ ସେ ବୁଝି
ଆପଣ ମେଡିକାଲ ପ୍ରେସକ୍ରିପସନ କଣ କହିପାରିବେନି ସେଥିରେ ଆପଣ ଡକ୍ୟୁମେଣ୍ଟ ଡିସ୍ପ୍ୟୁଟ କରିପାରିବେ ଆପଣ ଲାଷ୍ଟ ଦେଖିଲେ ଏତେ ସମୟ ଚାଲିଲା 362 30 ଚାଲିଲା ଏତେ ସମୟ କଣ ସେ ଡକ୍ୟୁମେଣ୍ଟାରୀ ଡିସ୍ପ୍ୟୁଟ
ଡକ୍ୟୁମେଣ୍ଟ ଡିସ୍ପ୍ୟୁଟ
ଆପଣ କଣ ଅବଜେକ୍ସନ ଫାଇଲ କଲେ ମିଷ୍ଟର ମହାନ୍ତି କହୁଛନ୍ତି ଯେ ଠିକ ଅଛି ଲେଟ୍ ଅସ୍ ଟେକ୍ ଅପ୍ ଦ ସିଏମ୍ APL କୋଉ ଅର୍ଡରଟା ଡିସିଜନ ହେଇଥିଲା ଆପଣ ଗୋଟେ ଅର୍ଡର ଅଛି 20/3/25 ଦେଖିଛନ୍ତି ଅର୍ଡରଟା ଦେଖନ୍ତୁ ନା ଆପଣ ଜାଣିନାହାନ୍ତି କିଛି ଆଚ୍ଛା ଠିକ ଅଛି ଛାଡ ଆଉ ଗୋଟେ ଜାଣିବାକୁ ପଡିବ just but you have to see 20/3 ଅର୍ଡରଟା ଦେଖନ୍ତୁ କୋଅର୍ଡିନେଟ ବେଞ୍ଚ ଟଚ୍ କରନ୍ତୁ 20/3ଟା ଲେଫ୍ଟ ସାଇଡରେ ଯୋଉ ବୁକ୍ ମାର୍କ ଅଛି ସେକେଣ୍ଡଟା ଦେଖନ୍ତୁ 20/3 Please read that.
This IA has been filed for condemnation of delay of above 2 years in filing the CMPA. I have issued 2 applications for condemnation.
I have perused the application. That is by the coordinate bench. For condemnation of delay moved by the petitioner. The application is bereft of any explanation. Should I comply calling? Now the same that your learned senior Mr. Mahanti is saying that there is no explanation.
Yes, they have filed additional application.
Additional file could
Yes, yes. In which they have enclosed the this prescriptions. This may be sent for verification if it's true.
Upon verification. ଆପଣ ହଉଛି କଟିଆ ଆର୍ଗ୍ୟୁ ଯୋଉ କଲେ ଆପଣଙ୍କର ବି ବୋଧେ ସେଟା ଇଣ୍ଡକ୍ସନ ହେଲା ବର୍ତ୍ତମାନ ଇଣ୍ଡକ୍ସନ ଚାଲି ସିନିୟର ଆସନ୍ତୁ either way she is not that confident lickly so whatever IA record mein achi IA has been filed for IA 208 of 2023 the IA has been filed for condemnation of delay in filing the appeal stop the coordinate bench by order dated 23-2025 had directed us after the coordinate bench after considering item Ms. Sujata Jana, Senior Counsel, along with this is for that for the petitioner. You are Mr. Misra.
My lord.
Utkal Kumar Misra.
I am for the respondent.
I'm sorry. Apano na Utkal Kumar Misra.
Yes, madam.
Utkal Kumar Misra for the opposite party. Yes, please.
This case. The divorce has been allowed.
Acha.
I
No, 125 is maintainable by the former wife. The express provision is there.
yes, even after divorce, it is
After
maintained.
divorce, it is maintainable. The other part is in it is
But if she
as the word is concubine.
if she is living on adultery, she is not entitled to. And due
Mr. He is
My lord, they are coming for now.
presentation. In fact, I could not understand what you were saying.
74,000.
They came, my lord, for satisfying judgment, maintenance order.
37,000.
If 125.45 please are there, then actually, of course, your learned senior is saying that 125.45 was not filed.
No.
But that is the ground stated in the 126.2 petition. That is our submission is.
As my lord, they have to comply.
When you are saying that whatever has been paid in the DB Act case and all these things, that
DBA case रे again 37,000.
whatever.
20,000.
18,000 thereafter paid 18,500. On
Judge
38.
family go to order to comply. Set aside, maintenance.
125 is a bar. Comply କରିବା ପାଇଁ 125.4 is a express statute. 124.5 that is in the statute. And you are saying that none of them is paying, so that is not contemplated in 120. Maybe both petitions can be filed because 120 does not presume a marriage. There can be a situation where the two persons living together, one can claim maintenance against other.
କିନ୍ତୁ ସେ ନିଜେ ଲେଖିଛି
Shamsiya versus Kushwaha. Further followed in justice.
ନାଇଁ ଏଥିରେ ସେ ନିଜେ ଲେଖିଛି ସତ୍ୟବ୍ରତ ରାଉତ ଆପଣ ପେଜ 39 ଟା ଏଥିରେ ହଉଛି ଅମିତ ଦାସ.
Satyabrata is friend of Mithyabrata. So Satyabrata and Mithyabrata, that is the problem now.
Yes. And she has filed law. So Lordship may keep it to some other day.
Yes.
Let me.
The learned counsel for appearance section. The learned senior counsel for the petitioner. Item 18.
18.
Counsel for senior counsel for the petitioner as well as the learned counsel for the other party were some length. It is submitted by the learned for the petitioner that there is no amount for the application filed by the petitioner under section 126(2) of the CRPC. It is submitted by the learned counsel for the opposite party that she has not received any amount apart from the cost of rupees 3,000 directed to be paid by the coordinate bench. Delay condemnation में हितला for abandoning the case. आपण किसी amount दियंतु मु एबे ऑर्डर
ठीक अछि
आपण तांगा तो सुनिले actually real trouble
ମୁଁ ଆଉ କିଛି କହିପାରିବି
6 ବର୍ଷ ହେଲାଣି କିଛି ପଇସା ମିଳୁ
ଅସୁବିଧା ବୁଝନ୍ତୁ କିଛି କୁହନ୍ତୁ you use your good offices ତାପରେ ଏଟା ରିମାଣ୍ଡ ହେଇଯିବ ଏଟା ରିମାଣ୍ଡ ହବ ମିଷ୍ଟର ମିଶ୍ର ଆପଣ ଖାଲି କହୁଛନ୍ତି ବୋଲି କିନ୍ତୁ ଏଟା 126(2) ରେ कोन रिजेक्ट केमति कर अपन ऑर्डर 9 रूल 13 रिजेक्ट को हबो whenever order 9 rule 13 comes to high court it is allowed so 126(2) has to be allowed
no lordship consideration my lord
consider karibe I cannot pay I am not supposed to pay also good advi good paisa my direct it is submitted sorry sentence complete helani delay. It is submitted by the learned counsel, senior counsel that some other amount has been paid by the petitioner to the opposite party in other proceedings such as DV Act.
DV Act.
Such as proceeding under the DV Act. Stop. The learned instructing counsel appearing for the petitioner shall obtain instruction to give the details of the payments already made in the form of a table, which shall be served on the learned counsel for the petitioner.
Opposite.
For the opposite party. The counsel for the opposite party submits that the opposite party is in distress and is facing vagrancy due to lack of payments. So the matters will be listed for orders in the week commencing. सतीश 4-20-26 आपण कोटे 20-30,000 टका जाले गोटे दियंतु the reason being that she is now suffering what Mr. Mishra is saying what may be the other aspect of it आपण छाडंतु सेटा so if that is the situation she has been deceived and duped by two persons सत्यव्रत and मिथ्याव्रत then it becomes
नहीं she has been she काहे की करिन बोली reverse.
Let us see.
Now
she is saying it is the reverse. Both Satya and Mithya have been duped by her.
Proceed direct to solve the plain copy matter. Plain copy
decision.
In item 17, the bail application was disposed of on 22/11/2024, and that order itself, the IA earlier for initial 3 proceeding already disposed of by your lordship.
Oh, acha. Seita mu pacharuthile apun. So seita but Mr. Kotkiya did not have that instruction. But item for lekhi diyo.
Amule lekhi di. I satho.
Page file debe ta ki nahi. Satyavangu debe ta file ta identify.
My lord, that order interim order में continue.
Interim order dated
16/5. 16/5.
interim order dated 16/5 shall come till the next set of hearing.
Proceed to solve a plain copy matter. मु पाई नहीं परंतु बापा मरि गेले
हाँ दे दे.
Yes, madam, please give.
Oh, bless.
Son born from the wedlock. The maintenance application has been allowed. Pending. Maintenance जोटा आपण फाइल करछंती.
Allow his.
The maintenance application has been allowed by the learned judge family court. Paras. It is submitted that Paranos it is submitted that the petitioner is facing difficulty to attend the case at Sambalpur initiated by the husband, and accordingly she prays for transfer of the same to the court at their word. Stop. Para. To notice along with this order. Requisites for issuance of notice by speed post with registration. Take your seat. With registration and proof of delivery shall be filed within 7 working days. Returnable date be fixed to 8/5/2026. The matter shall be listed in the week commencing 11/5/2026. Stop. Then IA 87 of 2026. IA has been filed seeking stay of further proceeding in the CP number 65 of 2025 pending before the Learned Judge Family Court, Sambalpur. Stop. Hard Learned Counsel for the petitioner. She reiterates her submissions as noted above. Stop. Subpara is to notice as above, except one set of process fee as well as postal requisites, along with the petition. The returnable date as well as the date of listing shall be as directed above. In the interim, it is directed that CP number 65 of 2025 shall be adjourned by the court in season. CP number 80 pending before the Learned Judge Family Court, Sambalpur shall be adjourned. To a date beyond 18/5/2026 as would be convenient to the Learned Court upon a prayer being made for the said purpose. Yes.
Item 13. If the brief has been taken away by the petitioner.
Mr. Sheikh Abdul Naim, kindly file your memo.
I am filing memo. No.
Mr. Sheikh Abdul Naim for the petitioner. The petition was presented before this court on 27/7/2022. After SR stamp reporting was made on 1/8/2022. It was indicated that certified copy of the impugned judgment was not filed. For removal of defects, it was listed before the Learned Deputy Registrar Judicial, into bracket judicial, law jima, on 24/10/2025, then when 3 weeks time was 3 weeks, as for apostrophe, time was granted for removal of defects. Thereafter, it was on 2/2/2026, 10/3/2026. When no one had appeared. As directed by order dated 10/3/2026, the order along with the date of listing was intimated by the registry. Through its cost through the office of the Secretary, Odisha High Court Bar Association, by speed post. Stop. The efforts of the registry has yielded result. The Learned Counsel for the petitioner appears and files memo which indicates the following. Apparently, the petitioner is not interested in prosecuting the matter. Quotation, the memo shall be taken on record, scanned copy be updated. Apparently, the petitioner is not interested in prosecuting the matter. The petition starts disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Cuttack, to be kept in the records of the criminal proceeding number 26 of 2015, decided by judgment dated 10/6/2000. Yes, next please.
Item 21.
The 13 to be passed over it, नहीं? Opening line the matter was passed over when it reached and is called again after resumption of the proceeding of the court post lunch. The learned counsel for the petitioner is present and heard.
Item 21.
Disposed of, sir. 21.
Your Lordship.
21 to pass over.
No, no.
Serial. Yes, 21, yes.
Your Lordship, on behalf of Advocate Arvinda Mahanti, the present case has been filed against the order of Lord Judge, Family Court, Cuttack, for enforcement of alimony. Instead of filing matter, we have filed the RPFAT, PFAT for. I'm sorry, Your Lordship, I'm a bit nervous.
No. Why you should be nervous?
I'm facing first time. Sorry, Your Lordship.
No. You are doing well. At least you have read the brief, you know what you are submitting.
Yes, sir.
Making mistakes, in fact, every day all of us are making mistakes.
Sir, instead of filing the matter.
You are challenging the.
No, sir. We have been filed the IA to change the nomenclature. Therefore, we pray the Honorable Court to direct necessary orders to change the nomenclature.
Yes. What's your name?
Sir, Badri Vishal Priyadarshan.
Badri Vishal
Priyadarshan. Yes.
So Badri Vishal Priyadarshan on behalf of Aravinda Mahanti for the petitioner. Opposite party blank. IA 586 of 2025. Stamp report dated 21/11/2025 indicates that the application has to be registered as MATA. Para. The challenge is to the judgment dated 18/6/2025, passed by the learned judge, Family Court, Cuttack, in CP number 76 of 2015. Filed by the wife seeking dissolution of marriage under section 13 into bracket 1 into bracket small I dash small b bracket closed. Let's complete it. Full stop. That in the present application, the wife seeks enhancement of the permanent alimony of rupees 2 lakhs awarded by the learned judge, Family Court. In view of the stamp report, the matter has to be listed as the matter has to be nomenclated as MATA. Check the word nomenclature, I think is available. MATA. The IA is favored and disposed, the prayer made in the IA is allowed. The petitioner shall take steps for conversion of the petition into MATA within a period of 2 weeks.
Yes, sir.
Within a period of 2 weeks or 10 working days. Within a period of 10 working days. The IA is favored and disposed of. Après ଆପଣ steps ନେବେ ସେଟା convert କରିବେ.
ଆଜ୍ଞା.
এটা ଆପଣ এটা draft କି ଆପଣ ନିଜେ କରିଥିଲେ?
ନା senior କରିଥିଲି.
Okay. Yes.
Obliged.
Yes, please.
Item 22.
ହେଲେ ବର୍ତ୍ତମାନ ହାଇବ୍ରିଡ୍ ବୋର୍ଡ ଲେଖିବେ ଆଉ ତା ଆଗରୁ ହାଇବ୍ରିଡ୍ ବୋର୍ଡ ଗୁଡା କୋଉଠି ଲେଖିବେ? ଆରମ୍ଭ ଆପଣ କେତେରୁ କଲେ?
7, 9.
7, 9, 13 ଲାଇନ୍ ଏବେ ଯୋଉ ଆରମ୍ଭ ହେଲା ଅନଲାଇନ ଟା ଏବେ ଏ ଯୋଉ ମ୍ୟାଟର ଏଇଟା କେତେ ନମ୍ବର ଆଇଟମ?
It is 21.
21 ଟା ହାଇବ୍ରିଡ୍ ବୋର୍ଡ.
Item 22.
କିଏ ଅଛନ୍ତି କି ଏଥିରେ? ବିସିରେ ଅଛନ୍ତି. The matter was heard at length on 20/1/2026. The propositions of law were discussed and noted in the said order. The learned counsel for the petitioner had adjournment to address on the legal issues. Stop. Today, when the none appears for the petitioner, when the matter is called, stop. To grant further opportunity, list in the week commencing 11/5/2026. बोध ହେଇଗଲା ନୁହେଁ 18/60 18/5/2026. In the week commencing 18/5/2026. Yes.
Item 23.
No, please, Your Lordship.
23, Mr. Naik, you are appearing.
Yes, I am appearing on the behalf of Suryakant Jaina, Your Lordship.
Okay. You are Mr. R. Naik.
Sritam Naik. Yes,
Mr. S.
SK
Naik.
Naik.
Mr. Sritam Naik on behalf of Suryakant Jaina for the petitioner. Yes.
Lordship, I am appearing, Your Lordship, challenging the judgment of the dated November 14 to 25, Your Lordship, passed with the learned Judge Family Court Navrangpur, Your Lordship.
Yes.
Directing the petitioner to pay 10,000 to the wife and 4,000 to the minor child, Your Lordship, per month.
Yes.
Lordship,
They had sought for 30,000.
20,000 they have asked, but
So 10,000
to the
30,000.
well, Lordship, in the judgment they have given 10,000 to the. They have asked for claim for 20,000, Lordship. In the judgment it's written, Your Lordship.
Page 13. Look at.
Maintenance of rupees 20,000 to the wife and the 10,000 to the Lordship.
So
30,000.
when you are saying they had asked, it has to be 30,000.
Yes, sir.
Yes.
Lordship, but the judgment was they have passed 10,000 to the wife and 4,000 to the child, Your Lordship.
Yes.
Lordship, by ignoring the fact that the petitioner is unemployment.
So your pleadings.
Lordship, kindly have perusal to page number 6, Your Lordship.
Pleadings before the trial court. You can't re-argue a revision application before a high court.
Yes, sir.
So you have to say so before this court. Interestingly, Honorable Justice Deepak Mishra's judgment is in a similar Samima Faruqi versus so and so, the similar matter. The Muslim personnel law.
Yes.
Sahid Khan. So what was your pleadings? Because incapacity to earn or lack of
Lordship, the
earning is a matter of pleadings and proof.
yes, sir.
So what was your pleadings before the learned trial court?
Lordship, that at the time when they have filed their maintenance, Your Lordship, the petitioner is unemployment.
That cannot be a matter of speech, of conversation. Suppose I know,
Yes, sir.
because I go to that place, may not be going. I know him personally.
Yes, Your Lordship.
Can I say that because I know Muhammad Mayur Jani is unemployed, I know, so that the court cannot do.
Lordship, even if in the second thing, Your Lordship, this.
First,
Yes,
let us not jump around.
Yes.
When you are saying that the court has not taken note of the fact that you are unemployed, lack of earning, then you have to plead and prove that.
Lordship, the petitioner was working in a coal mine, Your Lordship, and that time the office got shut
This
down.
cannot be a speech, sir. You have to show that whatever was what was
Yes,
your
Your Lordship.
pleading and what was the deposition, what was the evidence.
Lordship, they have not filed any assess liability in the affidavit in the lower court.
That is not necessary. Assets and liability is not necessary. And in fact, it cannot substitute the pleadings also.
Yes.
Assets and liabilities affidavit is in addition to your pleadings.
Pleadings.
Did you examine the pleadings first? Before drafting the application, you should have looked at the pleadings.
Lordship,
Otherwise, it becomes a kind of a debate competition.
Yes. Thanks.
And debate competitions are not to be held in courts.
I apologize for that,
No,
Lordship.
why should you apologize? Don't be
Because
apologizing.
I got assigned this matter, Lordship. I have not drafted this one.
No,
That
whatever
is
whoever has assigned you should have looked at the basic.
Exactly.
If you are saying that,
And the document has not been annexed. The termination letter and everything, whatever happened to the petition, they are not annexed in this petition.
annexed, it's not a writ application. You
The
are not
evidence.
arguing a writ application, you are arguing revision of a judgment passed by the Learned Judge Family Court.
Yes, Your Lordship.
So that is not, that jurisdiction is different. That section of, this is a revision application, 1904 of Family Courts Act, 442 of Bharatiya Nagarika Suraksha Sanhita.
1904 appeals.
And 442. So the complete different jurisdiction. And annexer are not to be searched here. There has to be pleadings. So whatever was there in the trial court,
Yes.
that you have to make your submissions seeking revision.
Lordship, maybe give another date. I will be doing all the with the everything, Your Lordship. What the pleadings are done in the lower court, Your Lordship.
It cannot be done in increments. High Court rule or this section 1904 of Family Courts Act
is
not incremental. First round, second round. It was very. I was sitting in Justice Vishwanath Rao. He used to always tell this.
Yes.
No, I am not. In fact, I do not dismiss the matters. That's another thing. Though that adds to pendency, but there is nothing. Anyway, have you looked at the judgment? How the judge has dealt with the income? Which paragraph?
Actually, I've gone through the judgment, Your Lordship.
Which paragraph they have dealt with?
Lordship, kindly have a perusal to page number 15, Your Lordship. Paragraph 2.3, Your Lordship. Page number 15, Your Lordship.
That you have not examined. As it seems, you have not examined. Anyway, but me examining doesn't help it also. The petitioner husband in the marriage is had no counsel for the petitioner. The petitioner husband in the marriage is before this court. Seeking revision of the judgment dated 14/11/2025, passed by the learned judge, Family Court, Navrangpur, in CR.P. number 27 of 2025. Stop. The said petition was filed under the provisions of Section 144 of the Bharatiya Nagarika Suraksha Sanhita 2023 by the wife in the marriage, aged about 29 years, and a minor son born out of the wedlock, aged about 1 year, seeking maintenance of rupees 20,000 for the wife, and rupees 10,000 for the child per month. Stop. The petition was favored. However, directing for payment of monthly maintenance of rupees 10,000 for the petitioner, for the wife, 10,000 for the wife and 4,000 for the child, from the date of filing of the application, that is 10.02.2025. It is submitted by the learned counsel for the petitioner that while deciding the application, the learned judge family court has not considered the aspect of income of the petitioner and also ignored the material on record indicating the income of the petitioner herein, who was the opposite party. The judgment indicates that the judgment indicates that the learned judge family court relied upon the evidence, the deposition of PW1 wife, PW2 another person. The opposite party husband did not examine any witness on his behalf, nor he deposed himself. No documents were marked on behalf of the petitioner as well as the opposite party husband. The learned judge has relied on the assertion that the petitioner herein, the husband, was employed as a senior engineer in JMS, page 17.
JMS Mining Private Limited.
Mining Private Limited at Vijuri, Madhya Pradesh. Also, statement dictionary. The mother suffers from mental illness and she feeds her child, breastfeeds her child. The child will become mad.
The mother was actually suffering from psychological disorder, Your Lordship. And
so that the child will become, if the child is breastfed, then the child will become a mad.
That's
as a lawyer, you have also some duty that when that may be the perception of the client, but should you state in the court? Let us ask you.
Yes. No, Your Lordship.
Can it withstand? Can it withstand any judicial scrutiny or scientific process? So that is how the judgment is so bulky. I don't know. He did not file any written statement. Maybe that is the version of. This is version of the wife that you started
She
accusing.
replied, yes, appearing to me.
Yes, the learned judge, the learned court has also taken note of the fact that the parents of the parents of the no parents. It is also note of the fact that the salary of the petitioner husband is 80,000. He has landed property to his family, along with his family, and the total income per annum is rupees 10, 000, 00, 10 lakh. It was also contended before the learned judge family court that the opposite party husband is able-bodied person who can work to earn his livelihood as well as maintain his family. Stop. Regarding the contention raised before the learned judge family court, as well, and now pleaded in the revision that the husband is incapable of earning, has been dealt with extensively by the Honorable Apex Court in Samima Faruqi versus Sahid Khan. Into bracket 2015 bracket closed 5 SCC 705. The said principles have also been reiterated in Rajnesh versus Neha. Solon. Into bracket 2021 2 SCC 324. Para 14. 16, 17, 18, 19, 14 to 19, Samina. To substantiate the submissions made on behalf of the petitioner husband before this court to interfere in revision, the learned counsel for the petitioner was asked to refer to the pleadings on behalf of the defendant for the learned judge family court. Stop. the said pleadings are not available before this court, as that has not been annexed. Stop. The petitioner has adjournment to address further regarding the above issues. The issues pointed above, issues indicated above. Petitioner has adjournment to address further. And above, stop. List in the week commencing. 11-5.
Yes, sir, Lordship.
11-5, 20-24.
Lordship, my only humble submission, Lordship, they have already filed an execution petition, Your Lordship. We need,
What is the law governing execution petitions?
So 144 up to Your Lordship.
It cannot be kept pending.
Yes,
44.3.
44.3, Your Lordship.
This court should not interdict. The law is that this court should not interdict.
Lordship,
execution.
we are ready to pay up 50% of amount.
Show your readiness before the executing court.
Yes.
Deposit it there.
Yes, Lord.
Let the court pass it. Then you come here.
Yes, sir.
The court may grant you relief, may not grant you relief, but that can't be in a predictive mode.
Yes.
Your willingness cannot be a ground for interference by this court.
Item 24.
Obliged, Lordship.
You want earlier?
No, 11.
Execution date. You have to advise. As a lawyer, you have to give correct advice, and then for the petitioner, whether he will listen or not, that's a different thing. For wife and in these costly days, for the mother and child, 14,000 is nothing.
Lordship, the situation is that he's unemployment right now, and he has already spent lakhs of money in
that you have to read those decisions. When a unemployed youth comes to you,
yes, sir,
seeking interference, revision of the court, you can advise him. Yes. Simply by mentioning paragraphs 14 to 19 of Samima Farooq.
Yes.
He has to work, do daily labor.
Yes.
And if he works in High Court like others are working, High Court it is 400 rather. Outside it is 700-800. I'm saying, giving an example in the sense outsourcing, not exactly High Court. The outsourcing persons who are working, they are getting around 12,000. Take home is around 9,000. Now the daily wage is around 600.
So 600
at least.
Yes, sir. Obliged.
Item 24.
May I please, Your Lordship? Your Lordship, there are a plethora of land acquisition appeal in this instant matter, wherein we have challenged the order of
Yes, Sanapati.
Yes, Your Lordship. We have challenged the order of the learned civil judge Hujang. Your Lordship, the opposite party number 1, the Chief Engineer, East Coast Railway, has also filed cross appeal. Your Lordship.
CGC.
But
cross appeal separate file.
in fact, she has not served a copy to us.
Your
So
Lordship.
let her serve a copy so that we.
Yes, Your Lordship.
A batch of cases are there, but a single copy is served. Copy they
We undertake to serve the copy by the end of the day.
Thank you.
Mr. Misra,
Hello.
you are appearing in?
I'm also appearing in this case.
In LA
stick to the
LA case number 27 of 26.
The issue that the camera, it doesn't see, then you can't be seen in the VC. That is the other problem.
We will give the list, my lord. Let them serve a copy. Also may reflect our name.
Mr. Senapati for the appellate. One by one kare padibo. LAA 23 of 2026. Item 24. Okay. So the declaration. Item. ସବୁଗୁଡାକରେ ଅଛି ଆପଣଙ୍କ ଡିଫେକ୍ଟ ଅଛି?
Lordship, 23 through 26, there is a defect for limitation, Your Lordship. We have the IA is ready. We will file it in the counter. The copy of the IA is also ready, Your Lordship. We will be serving it on the opposite parties, Your Lordship.
On payment of court fee?
Your Lordship, that was argued before Your Lordship, and Your Lordship,
So IA is to be considered and order has to be passed.
Your Lordship, in the limitation IA, that is to be considered. I have gotten the IA, but Your Lordship, the previous IA, Your Lordship had heard it in length, and Your Lordship was pleased to dispense it till the pendency of this particular these batch of cases.
Which order? Which order?
Uh,
North which habis?
yes, Your Lordship, just a moment. Item number 23.
Acha, sorry. So they have been converted to LAA.
Yes, Your Lordship.
Yes, yes. No, sir, by looking at the order, actually, I was thinking that this is again diary number. Today I faced.
They have somebody.
Sobudakare, Miss S. Senapati for the petition appellant, Mr. Jodaka list dekhidebe. Apankara special hello, Mr. Nandi.
Your Lordship, on behalf of
Mr. One type on lekhibe, CGC achanti, Mr. BB Mr. achanti, Senior Panel Counsel, Mr. Saptasindu Kashyap, Toda ja dekhibe. Mr. Mr. You are Senior Panel Counsel?
Yes, madam.
BB Mr. Senior Panel. SS Kashyap, Senior Panel. Alok
Senior Panel.
Yes, Senior Panel. Senior Panel Counsel.
Except D Gochat and SK Samantra.
Deepak Gochat, CGC.
And SK Samantra CGC.
SK Samantra, CGC. The learned counsel appearing for the Sobudakar state. In all matters, Mr. Sethi, you are appearing?
Yes, Your Lordship. This matter was with Advocate Prabhu Prasanna Behra.
Prabhu Prasanna Behra. So Prabhu Prasanna Behra, along with Mr. Suman Sikh. The learned counsel for the OP number 1 submit that they may be provided with copy of the appeal memo along with the papers and other IAs. So the learned counsel for the appellant shall serve the copies within 7 days.
Yes, Your Lordship.
Within 7 working days. The matter shall be taken up for orders in the week commencing 4/11 kebe. List koda galat.
11th May.
11. The matter shall be listed in the week commencing 11/5/2026. Nale 18 re asu 11 re bahut heigala nahi 18/5.
Again.
Yes.
Item 25.
Your Lordship, in item 25, I'm appearing.
Ms. Senapati, wherever there is a requirement of filing of any IA or any pleadings to be completed,
Yes, Your Lordship.
that you also complete.
Indeed, Your Lordship.
I'm not specifically directing because there will be confusion in the order. All matters are not identical.
Indeed, Your
Please do
Lordship.
that. Yes. Item 25 also you are appearing.
Yes, Your Lordship. I'm for the petitioner wife, Your Lordship. This is a transfer
Senapati
petition.
for the petitioner.
Your Lordship, on the last.
Awaiting appearance of the opposite party. After elections, he may appear. That you are thinking.
Your Lordship, I'm not aware. But the notice is served, Your Lordship. It is complete.
No, yes, it is complete, but there is a proof of delivery.
Indeed, Your Lordship.
Proof of delivery is a problem area. We are facing that.
Yes, yes.
awaiting awaiting appearance of the opposite party. List in the week commencing 27 This for orders in the week commencing 27 You have a stay order here.
Yes, Your Lordship.
So then it can go to 18/5. List in the week commencing 18/5 interim order passed earlier shall continue till the next date of hearing. Yes.
Much obliged, Your Lordship.
Yes, please.
Item 26.
May I please, Your Honor? On last occasion, Your Lordship directed to file one amendment petition for addition of one amendment.
Which direction? Order? I have not directed. Because I never direct this kind of orders. If I have done that should not be. So I have not directed. Anyway, you have filed amendment.
Yes, my lord. And consular petition also filed, but that has not been.
IA 109.
Yes, yes.
The IA लिखिबेटा 109 of 2026. The IA has been filed for amendment of the petition. Stop. Had learned counsel for the petition. The amendment is sought for at the stage of filing of the application before it is taken off for fresh admission and notices are issued. Stop. Considering the said aspect, amendment is allowed. The IA is favored and disposed of. Then para. The amended application shall be filed within 7 days, 10 days.
10 days.
Within 10 working days. The matter shall be listed for fresh admission in the week commencing.
Last week of this month.
In the week commencing 18/5/2024.
IA is there, my lord.
Sorry?
IA is there for stay of that suit.
Take up होगा तो?
बहुत दिन है जो डेट पर डेट हो और the adjournment may be given that what petition will file for the adjournment that may be allowed.
Is there any? आसु देखिए अपन नेक्स्ट डेट केबे अछि
Next.
सेटा जदि अपन ट्रैक न करिवे तो that becomes your listing will be effective so that you can make a mention that it should come up on a certain okay liberty to mention list on 18/5 अपन जदि चाहिबे मेंशन करिवे liberty to mention हैला जदि ता पूर्वरु अपन को दरकार हबो get the date when it is
माने one pass over I will just one pass over
ठीक अछि pass over आपण तो किंतु कंसोलिडेटेड फाइल करिवे ना
already filed my lord. Consular petition already filed.
केमती करछोंती आपण wait करिवे the order to be passed permitting you require leave of the court to file application.
Okay, I don't.
Also to file a consolidated application. अपने SR हबो अपन SR be made and the matter be listed for fresh admission. For date they give to list in the week commencing sufficient. Yes.
Item 27.
So Nityananda Behuria for the petitioner. Opposite party blank.
Last time, by Lordship's direction, copy has been served by the learned judge, family court, Bhubaneswar. Khorda, my lord. He has received the copy.
The learned counsel for the petitioner refers to the order dated 13/3/2026. Sita Pudina or Putra order dekhi? 13/3 no. 3/2/2026. Order of 2026 and order dated subsequent order dated 13/3/2026. The notices issued by this court to the registry of the learned judge family court for that have been served. Through court process, and the proof of service has been returned to the registry of this court. The notice has already been, the proof of service also indicates that the notice has been served on the learned counsel for the opposite party and the opposite party in person. And the next date of posting in the CP is 17/3/40 rupees. Para. None appears for the petitioner, despite sufficiency of the notice. The matter is adjourned to grant further opportunity. The petitioner, opposite party, sorry. None appears for the opposite party, despite the notice being sufficient to grant further opportunity to the opposite party. The matter shall be listed in the week commencing 18/5/2026. Learned counsel for the petitioner is present. The matter is listed for hearing under the heading for admission. The interim order dated 3/2/2026 is reiterated. The CP number 94 of 2023 shall be adjourned to a date beyond 25/5/2026 as would be convenient to the learned court in season of the matter, upon a prayer being made for the said purpose.
Item 28.
May it please your lordship. I am appearing for the opposite party, your lordship. Your lordship, I had appeared and filed wakalatnama on 4/2/2025, your lordship, but the same is not reflected in the record. The honorable court may be kindly pleased to allow me to file the fresh wakalatnama due course of time or any short date, and we'll file a counter as well, your lordship. Kindly adjournment may be allowed 2 weeks adjournment.
That is, my lord, 1 year before, there is a submission by the learned counsel that they will file wakalatnama. Thereafter, in a date also it was said that wakalatnama is not there on the record.
Again, ଓକିଲଙ୍କ ସାଙ୍ଗରେ ଲାଗନ୍ତୁନି
ନା ସେଟା
ରିଜନ ହଉଛି ଅନଫର୍ଚୁନେଟଲି କେତେବେଳେ ଆପଣ ଓକିଲତନାମା ହଜିଯିବ
ଆଜ୍ଞା କିନ୍ତୁ ଏଇ ପ୍ଲିଟା ସେ ଯୋଉଟା ନଉଛନ୍ତି
ସିଚୁଏସନ ହେଇଗଲାଣି
ଆଜ୍ଞା
ଯେ କ୍ଲାଏଣ୍ଟ କଥାରେ ଓକିଲଙ୍କ ନାଁରେ 340 ଆପ୍ଲିକେସନ ଫାଇଲ ହଉଛି
yes very unfortunate things being happening
ସେ ଜିନିଷଟା ହବା କଥା ନୁହଁ କାରଣ ହଉଛି that it is a possible that misfiling ହେଇଯାଏ misfiling ର ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ସେଟା ମିଳେନି misfiling ଆମର ଯୋଉଟା କହୁଛନ୍ତି miss ମାନେ not MISS
no
mistake filing there is no misfiling as misfiling.
It is misplaced.
To say, first argue the Mr. case, then you argue the misplaced.
Misplaced.
Apno number gote bhul hei gale, seta misplaced huye, tapar seta track kari huye, because there is no system to kon heitio kahi hoboni. Maybe semane file kar nathibe, possibly, but jodi heichi jane kahuchandi seta to record re achi. Now there is a judicial order recording that they will file.
Yes, my lord. They have to file.
In fact, that is reflected in the office note also.
My only submission is that, your lordship, since they are saying that they will file, I am not objecting. I am getting 7,000, he is getting 4 lakhs. Your lordship has to decide. That is the only question. I am getting 7,000, my asset liability affidavit with all salary slips for last 2 years.
Direction kete deychandi? Mane heichi kete?
15,000.
10,000.
That your lordship has to decide.
15,000 is not that less.
That your lordship has to decide.
Though it will not be a fortune, I mean 15,000 is reasonable.
He is getting 4 lakhs rupees per month. So accordingly,
interim na section 24, 25.
My lord, 24.
24. Other proceedings called pending achi.
9. That your lordship has, this is the only.
Resumption of matrimony possible no.
Nah. See, I have filed restitution of conjugal rights. Your lordship may kindly.
That is pending. ମୁଁ ସେଇଟା ପଚାରୁଥିଲି ଆପଣ ସେକ୍ସନ 9 ଆପଣ ଫାଇଲ କରିଛନ୍ତି
ଆଜ୍ଞା
ସେ କିଛି ଫାଇଲ କରିନାହାନ୍ତି
ନା. That your lordship has to decide as to its difference amount is so high. I have paid 50,000. And I persuaded PSD. I said that that is 3,25,000 you pay. That is my educational expenses. That he denied. The documents I have filed. At least I am reading, pursuing PSD for my future purpose. That
इतने भी mediation एक केस रे maintenance से mediation ही परिवार. When there has been an award and both of you are educated. Yes, Miss Das, you obtain instruction. If it can be.
I will file.
I mean, if he can take 2 steps ahead and at least I am sure Mr. Misra will ask his client to accept that also.
your lordship may record my submission that from court itself I will go with him. My submission may be recorded with instruction I am submitting.
Aji Sokal last matter about Deri Hala Khaya Jivari, that was interesting. The fact of life is always stranger than fiction.
The
husband has filed an application for denial of 125 maintenance on ground that the girl getting married. The learned counsel says that both of them are friends. I could not follow what is both of them are friends. Then he says that both the husbands are friends and no one is paying maintenance. Mr. Misra was present.
Yes.
So, human behavior is very.
Time and again, time and again.
I hope Ms. Das will make an effort.
Yes,
yes.
I mean, that could be the reason she is not getting Wakalatnama. Because every time he visits, the husband visits, he says that you go for mediation. Then he turns away, does not sign the Wakalatnama.
Lordship may call it on fresh admission so that matter can be sent to.
At least you are having 15,000.
Again.
4,000 भी stay की पड़ी.
Again.
That's the problem.
मैं कहता था mediation को पठाई परियोगे. I am ready for that.
सी निजे करो ना अपन. इटा अपना level ले जो mediation दरकार नहीं.
Again.
Both of you can work it out. What a reasonable amount जति है जी बो. Then may not be 50,000. What a किसी और amount body ले है ला.
Let them take instruction to that. Again.
बाकी the other part resumption of matrimony, Ms. Das, you have heard. Please make an effort.
Yes, sir.
Now, Wakalatnama debe nahi ho.
So we will file it, Your Lordship. Definitely we will file it.
He has to file the Wakalatnama now. She runs the risk of not getting the Wakalatnama. So much Misra for the petitioner.
Ashutosh Misra.
I'm sorry, Mr. Ashutosh Misra for the petitioner. Ms. Suchispita Das for the opposite party. Office note put up by the registry indicates that as for the information received from the computer filing assistants dated 24/2/2025, Wakalatnama filed by learned counsel Ms. Das reflected in the order passed by the coordinate bench dated 4/2/2025 could not be located. Stop. For a hybrid mode, the learned counsel for the opposite party being present at virtual court High Court of Orissa, Khurda at Bhubaneswar addresses arguments. Could not be located. Ms. Das learned counsel submits that she shall file Wakalatnama. Submitted by the learned counsel for the petitioner that the income of the opposite party husband at rupees 4 lakh per annum per month.
Per month, my lord.
Oh, kilo na kon?
No. SARC Development Authority Bhutan is the executive director. Your lordship may kindly pay 65.
Those figures.
I am not. I am at least not that fortunate lawyer. No. Some other lawyers.
No. By the time you feel that you can earn, so
again.
Those kind of figures only possible for lawyers. Nothing for a lawyer. Mr. Misra, that is nothing for a lawyer.
Yes, that is true, my lord.
Your Lordship, they have filed an execution as well in family court.
Fees for per case, per appearance. Obviously, that would be. And it is all tax paid. The client will pay the tax. You don't have to pay the tax also. As presented before the learned judge family court in the application 125
No, 24.
Under section 24 of the Hindu Marriage Act seeking interim maintenance.
ନାଇଁ ସେଠି ମୁଁ ଯୋଉଟା ପ୍ରେଜେଣ୍ଟ କରିଛି ସେ ତାଙ୍କ ଅର୍ଡରରେ ରିଫ୍ଲେକ୍ଟ କରିଛନ୍ତି ସେଟା ହଉଛି 2,06,610. That is February.
I'm not recording. I'm not going to that figure.
ଆଜ୍ଞା.
Seeking interim parental right maintenance in the application filed by the wife under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights would indicate that the opposite party is capable of paying maintenance much more than 50,000 per month. 15,000, sorry. 15,000, much more than 15,000 as directed by the learned judge family court.
Your Lordship, apology for mentioning, Your Lordship. Their file in execution is well in family court Bhubaneswar, wherein we had cleared all the dues. We had paid 12 lakhs and on last day.
Just one. Don't be anxious. Actually, there is some problem in electricity and also your voice is breaking. Just
Yes,
wait.
sir.
Let me complete this. I'll come back to you.
Yes, sir.
Can pay maintenance much more than that has been directed to be paid at rupees 15,000 per month. Or the learned counsel for the opposite party submits that the opposite party has already paid the amount directed in the execution matter pending, filed and pending, disposed of.
No, pending.
Pending before the learned executing court.
Has been disposed of.
That is a fact, Your Lordship. That's a fact. He has paid 15,000. That's a fact. He's not saying wrong. That's a fact.
In last execution, Your Lordship, we had paid 1,26,000 as well in January.
Don't be anxious.
I am saying that I am admitting.
Go by the trend that I asked that how much you have paid. So I am not saying that you have not paid.
I am admitting that.
No. In fact, I am not saying that. I am saying something else. I am going to mediation actually. Has been paying for this. Has been paying the amount as directed towards maintenance. In the execution matter, has been paying full stop. Looking at the facts of the case, age of the parties, their education, it appears that the parties can arrive at a settlement amicable. Can arrive at amicable settlement acceptable to both the parties. The learned counsel for both the parties are requested to make all endeavor for achieving the same. Stop. The learned counsel for the opposite party shall file her wakalatnama within 2 weeks.
Yes, sir.
The matter shall be listed for orders in the week commencing. এটা তো আপনাকে এটা কইছেন যদি মেডিয়েশন হেই নই পারে ফির হিয়ারিং করিয়া পড়ে
আজ্ঞা মু সেতপই কইছি ফ্রেশ এডমিশন নে আসু যদি
অর্ডর সে আসু দেখিবা
আজ্ঞা
will be listed for orders in the week commencing
end of this month, my lord.
ଆପଣ ପରସୁଏଟ କରିପାରିବେ commencing 4/5/2026
ଆଜ୍ଞା.
Yes, next.
Obliged.
Item 31.
31 টা বলতে সে মেনশন করতে লাগি সো মাহান্ত 31 পাস ওভার করে দিন তো ডেট করে দেবে somebody
Item 32.
Mahanti, so Haripada Mahanti for the petitioner, Mr. Satyanarayan Mishra for the opposite party. Not here. Just 1 second. I'm sorry. Correct the order. There is a mistake. I'm sorry. Fine. The registry has indicated the inadvertent typographical error in the order dated. 17-3-2026, wherein the order number has been wrongly typed as 2 instead of 3. Stop. The necessary corrections shall be carried out as per rules in the said order. Dated 17-3-2026. Yes, Mr. Mahanti.
Well, Lord, here I am challenging the impugned order passed by the High Court Bhubaneswar, which is at Annexer 5, page 47, it starts. Your Lordship may see. Your Lordship may see. Here, in fact, the court comes to has recorded that the husband has not been able to, has not laid any evidence nor participated in the proceeding. That I will show your Lordship.
Yes.
Page 49, para 3. Though the opposite party has affected his appearance, but has not filed his written so cause, neither cross-examined the adversary, nor has adduced any evidence from his side. Now, my lord, I take your lordship to the page 34. That's the order sheet. Case record, order dated 18/7/2024. Case record is posted today for evidence of OP as special chance and for payment. Both parties are present with their respective counsel. The OP did not file the evidence affidavit in spite of several opportunities given to him. Hence, the evidence of OP is closed. In the meantime, counsel for the OP filed objection of petition praying to dismiss the said matrimonial complaint. Copies are served. Further, counsel for the petitioner filed a memo annexing with the balance sheet of area maintenance dues, however, put up on 31/7/2024 for objection and hearing. My lord, I filed the opposite party therein before the court below, filed a application challenging the maintainability. Both the parties are present with their respective counsel. Counsel for the OP filed evidence affidavit along with a memo annexing with the documents.
The problem hela closure pore.
Yes, my lord.
Tale apon seta closure ta challenge korthante na.
Yes, that was the mistake. But your lordship may see the court records that
the court's hands are tied.
Yes, my lord.
After this CPC has been amended also, it is more tied.
Yes.
Now it is further tied. High Court is pressing upon the breathing on their neck. You dispose of application.
Yes, that's true.
Supreme Court then says that why these matters are kept pending.
Correct.
So there are so many issues. So after, if you wanted, then at that stage,
actually setting aside application,
at least you could have filed application for the court to reconsider its closing evidence. Correct. Suppose that application is not favored. Favored, Mr. Mishra may have challenged. But if it is favored, then things get normalized.
My lord.
But that opportunity is lost.
Yes, my lord.
Because the trial court, after passing an order, cannot revisit.
No, my lord. That is not. But here, what is my submission is, my lord, that they took my evidence on record, evidence on affidavit on record.
Not record, it is filed.
Yes,
the problem is that, as you have said very fairly, that after the order was passed, closing evidence.
Yes, I should have.
It happens many a time. They start filing, doing things, but the court cannot recall it.
No, my lord. My lord, I was praying, my lord, if the matter could be remanded, the reason being, I have not got any opportunity of hearing. But I obviously for my conduct, because I have not filed
opportunity of hearing was given, but it was not available.
Yes, I corrected myself thereafter.
Because the problem, I mean, these things are no more available. Earlier, it used to available after 99 amendment or 2001 amendment of CPC. Everything is now, timeline is there. Timeline is there. And in fact, in the if you mark, जो order है से कॉले close कॉले evidence ना देखो तो कितना number order. Order number you'll get indication.
The order number ta देना थी. Order date खाली पड़ती number नहीं.
Mr. Mishra, but before that, much time would have been given.
Yes.
Sufficient time given.
Record bhi hai.
And he didn't prefer to cross-examine. Thereafter only.
Even actually, that I was also thinking. Even without filing WS also, you can cross-examine.
Yes.
Can be.
Yes.
That is also not done.
Yes.
In fact, I am looking at 53. Look at page 53. Because the last page gives the entire sum and substance of the entire evidence. Internal page 7 of the judgment. Upon a witness भी दे परिवे. Without WS also you can examine.
Yes.
You can be yourself a witness also.
Yes.
Nothing has been done.
No, I cannot develop any.
I mean, in matrimonial matters, they are not responding to lawyers even.
Yes.
That is the other problem.
But here he has quite a few times.
It's a very, the conduct of the matter has been conducted by the person he has not taken responsibility. It is so easy to blame a lawyer. Ultimately, you say the cross-examine colony.
Record the he was present, his lawyer was not present on some occasions. Not that
alternative matter. When he is present, his counsel is present. Counsel is not present.
She decided jail jone rahibe so that adjourn kariyo.
Say it nahi. But yes.
It could be.
Yes, Malad. I cannot because I have not seen. So I cannot make
lighter vein, but that can be a strategy.
Malad, what I was praying, subject to your
no, this cannot be. This is not that kind of a case. And now the problem is that again, further the matter has been adjudicated, completed, then it can't be reopened.
No, Malad, one thing.
It is 125 and 24 application.
125.
125 file kole any application for seeking any modification.
No, modification se boda maintainability se seta ku not ki je setting aside that order. He filed a modification application. The court,
modification of judgment and jota closing evidence.
Nice. Mane se recall deiki ni mane acceptance petition deiki daba kotha. Se dele maintainability of petition which was not at all applicable. May see for your lordship's consideration. Here what has happened? He is filing the crux of the dispute is that the marriage lasted only.
2020 आरंभ हैला सरिला केबे
2000
जजमेंट केबे हैला
26 13/11/20
आपण जदी कोन how the high court will interfere
नहीं 2000 the first time notice was
20 6-8 notice issue ହେଇଛି
तापरे interim maintenance रो order हैला
whatever आपणकर 4 years is sufficient.
I have even
which way the high court will interfere? Nothing.
Difficulty is, my lord, your lordship may see, I understand that, my lord, evidence is not on.
Quantum modification by jo provision achi. Quantum modification.
Quantum, I am dispute. My lord, may I just show one line from the judgment?
Yes.
2-3 lines, my lord. My lord may see. Lord, it may not be out of place to mention here that an order of maintenance cannot be where the husband had neither ill-treated the wife nor has refused or neglected to maintain her, but she is of her own accord and without any just ground left the husband's home and refuses to live with him. Lord, here my
sorry,
it is page 50.
Yes, 50 and there, yes.
And the second para, last 5 lines.
Subpara.
Yes, madam.
It may not be out of place.
Yes, it may not be out of place to mention here that an order.
That is the discussion by the.
The entire case is the evidence on affidavit which was filed. Though subsequently, there my specific ground is she was the dispute started when we went for a medical checkup, and it was found that she is pregnant, and the pregnancy dates back before the marriage. So that's the entire case. So and the dispute started only a month.
125 race it happened.
No,
125 race without marrying,
but adult.
upon seda the ground in na
nahi seta nahi thulna se 80% evidence on affidavit ta my lord dekhontu seta on record
presumption of legitimacy of the pregnancy is there post marriage is not disputed,
no matter,
so that the legal strategy is correct.
They say date
if that would have been the case, if
नहीं,
the
मुझे-
trial court, it would have been rejected.
मतलब मुझे डायग्नोस्टिक रो रिपोर्ट टा सी एडमिट करछन से प्रेगनेंसी
डायग्नोस्टिक रे हेले आपनको सेटा को आपण से मेडिकल डायग्नोसिस बही देखिया पड़िबो, एक्सपर्ट ओपिनियन आनिया पड़िबो।
नहीं, सेटा सेठी
से रिपोर्ट रे लास्ट लाइन प्रॉब्लम पड़िबो,
मेडिकल लीगल not
because they don't want, they are not certified.
नहीं मतलब
determination of I mean pregnancy is a difficult task. It is not that easy.
Alert, the only thing which will happen if alert subject to your lordship say I have for my conduct
para 6 ta पढनु तापर
para 6 of the judgment.
If marriage is solemnized on 7/7/2019.
Okay.
There will be so many issues, Mr. Mahanti, if you dispute the marriage, whether he had access or not, all there are so many things. That is not
7/7/2019 is the
125. Any kind of relationship, the person, the woman and the man staying together is enough to claim 125.
Yes, madam.
Divorced wife can claim also.
Yes, madam. But if she stays in adultery by any chance, if it is proved,
जे सेटा तो जज प्रेडिक्ट करबेन, जज तो इट इज नॉट ए क्वेश्चन दैट
नहीं, एविडेंस लीड
क्वेरीज सेटा आपण एटा एकेडमिक कर देले जिंस
नहीं नहीं मु जदी
आपण जदी से प्ली नै थांते, से प्ली रे एग्जामिन करि थांते ताकू, तापरे एविडेंस देई थांते, जज
सेटा
दैट ओपिनियन फॉर्म करि थांते,
दैट अपॉर्चुनिटी
सेटा सेकंड इनिंग्स रे हबनी, as very aptly always said by Justice Rathod, first second quarter final semi-final second hab, trials are to be conducted in a structured manner prescribed by CPC. Now even I 227 power is very also circumscribed. How can I reopen the evidence closed? I cannot. Now what you are saying that you might have a good case, but you should have filed the pleadings. He is a government servant.
Yes, sir, getting 70,000.
He is a PO.
Secretary.
Peon तो सेटा आपन ऑफिशियल 70,000 सेटा आउट दिन्छ
नहीं मतलब
वर्तमान बहुत जण भाबुछन जे आमे पिओन हेतले भलो हेता। पिओन नो ग्रुप सी
नहीं पियोन ना मतलब
1850 तक आरंभ हुई पियोन रे सेटा ग्रुप सी रे सेने there is nothing. You have made your argued the case that much, whatever best can be argued. Sir, आपनकर monthly maintenance कटुच माने salary कटुच
कटुतला एबे स्टे थिला 1 lakh deposit subject to 1 lakh deposit which I had deposited.
There is no case. से बर्तन आउथरे भाई गेले ना
ना
के ना के माने ये बा से तरह से माने dispute my lord, but I have but as your lordship has already I have argued my lord, so I cannot repeat the same thing. Your lordship just
no, there is nothing actually. This is
what I was
mane if he had a good case to present, he should have presented.
Yes,
court gave him 4 years, that is not enough. Then he could have cross-examined, he did not.
ऐसे कोविड पीरियड
he could have examined himself, he did not.
ऐसे कोविड पीरियड टा माय लॉर्ड तो से पडुची ता भितर ना 2019 ଆଉ 20 इंटरवेनिंग
आपनकर जो चारि एक 22 परे किछि कोविड नथिला
नहीं नहीं मु सही जो माने 19 टू 20
रु आपनकर कंटीन्यूअसली चालची केस
यस 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 मतलब मु
डेट हेछि 7/12/22 पर्यंत
मतलब आई वाज ओनली
12/22 रु चालची फेरे जाकी
12/6/23 the cross examination deferred. Only on 14/8/24 he filed the application that not maintainable. He should have filed earlier.
Correct. Neither he did, in fact, it was not challenged also.
Yes.
Neither his application was filed to recall that order. आपन इंटरिम मेंटेनेंस भी आवड हेची 11/1/23
yes
And obviously, these kind of allegations will spoil your relationship. You have access to your wife, and now, I mean, the person has access to his wife, and now he denies the paternity. It's very difficult.
No, my lord, just 3 months after marriage, my lord. Less than 3 months after.
The way you are saying that, that is which is absolutely possible, you are saying that impossible. Anyway, that's different issue altogether. Third learned counsel for the petitioner. Appearance section. Both of you take your seat. Judgment. Learned counsel for the petitioner at length. The learned counsel for the opposite party also made his brief response. Stop. The petitioner husband in the marriage is before this court, challenging the judgment and order dated 13/11/2024 passed by the learned judge Family Court Bhubaneswar in criminal proceeding number 99 of 2020. The CR.P. number 2020 was filed by the wife in the marriage under section 125 of the CRPC, into bracket, since repealed and substituted by pari materia provision contained in section 144 of the CRPC. 44 of the BNSS 2023, bracket closed. The petitioner wife had claimed rupees 40,000 per month towards her maintenance and rupees 20,000 as one-time litigation expenses. The petition was favored. However, directing payment of rupees 8,000 per month towards maintenance from the date of application, that is 6/8/2020. The entire order sheet of the proceeding, starting with the date of issuance of notice dated 19/8/20 by the learned judge Family Court Bhubaneswar, till the order dated 10/7/2023 has been filed before this court. till लिखले नहीं किसी डेटा चेंज करे 13/11/2024. The learned Judge Family Court has relied upon the statement of the petitioner wife as PW1 and 5 exhibits marked on behalf of the petitioner wife stuff. Apparently, the opposite party husband have not filed the written statement by the time the evidence was closed on his behalf by order dated, Mr. Mohanty, evidence was closed by order dated? Order dated as. Stop. It is also indicated that the opposite party husband chose not to cross-examine. Sorry?
18/7/2024.
18/7/2024.
Yes.
Not to cross-examine the VW1. He also did not examine himself nor adduced any other evidence or exhibit before the learned trial court. Though it is contended by the learned counsel for the petitioner hearing, with learned counsel for the petitioner before this court, that the proceeding before the learned trial court was impacted due to the COVID pandemic. But it has to be noticed that the proceeding was substantial, starting with the order dated 21.02.20 21 2 paise till it was disposed of. When there was when COVID pandemic had receded and life returned to normalcy. Stop. The order closing the evidence from the side of the opposite party husband has not been challenged, nor any petition was filed for recall of the said order, which could have been considered by the learned judge at the court. Stop. ଆପଣ ଯୋଉଟା ଫାଇଲ କଲେ କୋ ଅର୍ଡରରେ କହୁଥିଲେ ପଛରେ ଗୋଟେ ଫାଇଲ କଲେ?
Yes.
18/7/24. 18/7/24.
The learned petitioner refers to the order dated 18/7/2024, na?
Yes. 31/7.
Sorry, sir?
31/7.
18/7 ଟା ଆଗ ଦେଖି ଦିଅନ୍ତୁ।
नहीं 18/7 हला जोटा क्लोज हला मतलब एविडेंस क्लोज हला 18/7.
No, no. He filed a petition praying to dismiss the said matrimonial complaint. That is my lordship.
সেটা
Oh, petition.
18/7.
সেটা মিস্টার মহান্তি भी रेफर कल।
18/7.
স্যার
आगे से पिटिशन टा फाइल कर लिए 18/7. Petition for maintainability. Page 34.
18/7.
Yes, yes.
Order dated 18/7, which is reflected in the order dated 18/7/2024. Quote कर देंगे. Before the said order, the order stated 20/5/2024, 22/6/2024, 8/7/2024. Have to be taken note of. Stuff. In view of the orders passed prior to 18/7/2024, the learned judge family court was correct in proceeding with the matter for further adjudication, as the evidence from the side of the opposite party was closed. Thereafter, the order dated 31/7/2024 and 14/8/2024 passed by the learned court, family court, have to be noted and are reproduced here. Para. Scope of interference, this court, in orders passed by the Learned Judge Family Court, but the Learned Family Court, particularly in matters that is under consideration, that is application seeking maintenance under section 1. On behalf of the petitioner, the docket annexer 4, the order sheet maintained in the proceeding, the reasonings given in the judgment, it has to be held that there is nothing perceptible which would show that the judgment passed by the learned judge is a sanctuary of errors. Rather, full stop, comma, rather, comma, it has to be held that the judgment is based on proper appreciation of evidence on record. No. It has also to be held that by avoiding the maintenance, considering the income of the husband, substantial justice has been done. Therefore, done full stop. In view of the above discussions, it has to be and is held that this court cannot interfere with the judgment passed by the learned judge. Cannot do. No interference is warranted. No, this court category. No interference is warranted in exercise warranted by this court in exercise of divisional jurisdiction. Stop. Accordingly, the application is dismissed.
Well, my name may be replied as
Satyanarayana.
4.
Apna 4 ହେଇଗଲେଣି
ଥିଲି
ଆଜି ଗୋଟେ 100 versus ସତ୍ୟନାରାୟଣ ସତ୍ୟନାରାୟଣ versus ସୁଆଂଶୁ ଯୋଉଟା ମିଷ୍ଟର ମିଶ୍ର ହସୁଛନ୍ତି ସେଥିରେ I name the other person as ମିଥ୍ୟା ନାରାୟଣ.
Item 34.
Let's. Yes, please.
Item number 31, my lords, I pray apology, my lords, I couldn't be there, my lords. So
31 ଟା ପାସ ଓରି ତ ଆଚ୍ଛା ଏବେ କଲ୍ କରିଥିଲେ ଆଚ୍ଛା 31 ଗୋଟେ already you have crossed the time. These are all hearing matters. So it would not be, in fact, maybe you did not appear, but other matter was heard. Mr. Mahanti's matters, Nicholas matter.
You lords,
Date kar diyo to hame oda. Now there is no point in opening another brief and start hearing. The paucity of time has intervened. 31 ଗୋଟେ date kar diyo to 11/5.
My lords.
Week commencing 11/5.
Sorry, well, in that case, interim orders.
Order passed earlier. Yes, that is important. So, I mean, he should have done, Mr. Mahanti, he has left. Interim order passed earlier stands vacated in view of the petition having been dismissed. The payments made in the interim during pendency of this application shall be adjusted towards the monthly maintenance dues to be paid to the opposite party wife by the petitioner husband. The parties shall work out the calculations accordingly. ଏବେ କଣ ମେଣ୍ଟେନାନ୍ସ ସେଟା ଏକ୍ଜିକ୍ୟୁସନ ରେ ଅଛି
ଅର୍ଡର ଅଛି ତାଙ୍କର ଟୁ ଟେକ୍ ଲିଗାଲ କୋର୍ସ ଇଫ ଫେଲ୍ସ ଟୁ ପେ
ଆଚ୍ଛା ଆପଣ
ତ ସେଠୁ ଦରମାରୁ କଟୁଛି
ଦରମା ପାଇବେ
ଅବ୍ଲାଇଜ
ସେ ଜୁନିୟର ଆସିଷ୍ଟାଣ୍ଟ ଆପଣଙ୍କର ପିଅନ କହିଲେଣି କଣ କହିଲେ ଆପଣଙ୍କ ପ୍ରିଡିଂସ୍ ଅଛି ଜୁନିୟର ଆସିଷ୍ଟାଣ୍ଟ କାହିଁକିନା ସାଲାରୀଟା ବି ଆକ୍ଚୁଆଲି ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ 57,000 ଇଜ ନଟ୍ ସ୍କେଲ୍ ଅଫ୍ ଏ ଗ୍ରୁପ୍ ଡି ଏମ୍ପ୍ଲୟି
Law and court also had
ଗ୍ରୁପ୍ ଡି ପ୍ରମୋସନ ପାଇକି ସି ହେଲେ ଯାଇକି ସେମାନେ ସେ ସ୍କେଲରେ ପହଞ୍ଚିବେ ସୋ ଆଇ ୱାଜ୍ ଥିଙ୍କିଂ ଦ୍ୟାଟ୍ ଏଇଟା କେମିତି ହେଲା ଆପଣଙ୍କ ପ୍ରିଡିଂ ଦେଖିବେ ଅଛି ଏନିୱେ 31 ଡେଟ୍ କଲେ 33 to 39 33 yes sir
37, 34.
34 before vacation ଚାହୁଛନ୍ତି ମିଷ୍ଟର ଦଳେଇ
ଆଜ୍ଞା
week commencing କେବେ 18/5 କାରଣ 11/5 I think it has crossed now 100 नहीं 4/5 ଟା 100 100% week commencing 11/5
38 million.
38
Hello.
ଚାହୁଛନ୍ତି vacation date
Stay order stay ନାହିଁ ଏଥିରେ ଆଡଜର୍ନମେଣ୍ଟ ପାଇଁ ଲିବର୍ଟି ଦିଆଯାଇଥିଲା ଦବାକୁ ଗୋଟେ ଆଡଜର୍ନମେଣ୍ଟ ଦେଲା ତାପରେ ସେ ପ୍ରୋସିଡ୍ କରୁଛନ୍ତି
38 ଠିକ ଅଛି
38 27/4 କୁ ପୋଷ୍ଟେଡ ହେଇଛି
So my lord, any short date mean?
27/4 କୁ ଆଜ୍ଞା
38
Yes, sir.
Mr. Rabindra Kumar Sahoo for the petitioner, Mr. Rajkishore Swain for the opposite party. The matter could not reach as paucity of time intervenes. It is mentioned by the learned counsel for the petitioner. The interim order dated.
There is no interim.
There is only
The adjournment order.
yes sir
seeking reiteration of the adjournment order dated 23/12/2025. Para. Accordingly, it is directed that the MATCS number 62 of 2025 pending achi.
before the order civil judge
Into bracket
senior
division Bir Maharajpur shall be adjourned to a date beyond 25/5/2026 as would be convenient to the learned court in season of the matter. The matter shall be listed in the week commencing 18/5.
I think 35 million.
35, yes sir.
Direction also.
35 ଆପଣ ଚାହୁଁଛନ୍ତି ଲିଷ୍ଟିଂ ପାଇଁ ଡେଟ୍
Yeah, date.
18/5
There is interim order 35.
35 ରେ ଆପଣଙ୍କର ଡିସ୍ପୋଜ ଅଫ୍ ଏଇଟା ହେଇଯିବ କହୁଥିଲେ
No,
Time matter.
it no, it contest.
35 ତାହେଲେ ମିଷ୍ଟର ବିଭୂତି ଭୂଷଣ ମିଶ୍ର ଫର ଦ ପିଟିଶନର ୟୁ ମିଷ୍ଟର ସାହୁ
J. Mahapatra.
Mr. J. Mahapatra for the opposite party. The same order କରିବେ ଆପଣ interim order କଣ
Interim order. Interim order.
stay ଅଛି ନା
Stay.
ତାହେଲେ simply date କରିଦେବେ I am not touching interim order 35 order ଲେଖନ୍ତୁ 35 adjourn date କରିଦେବେ 18/5 week commencing 18/5 date କରିଦେବେ yes sir
36
item 36
37 ରେ
36
stay order ଅଛି
yes
stay order is not
yes
beyond 32 I am not touched passing
Yes.
any order
Item 37 matter. I am for the petitioner.
37 ରେ କଣ adjournment order ଅଛି
State channel.
stay I am not touching ଆପଣ date ଯଦି ଚାହୁଁଛନ୍ତି
ମାନେ previous date inadvertently the
36 I am for the I am in a VC item 36 I am for the opposite party
inadvertently
no, see he's Mr. Sahu is mentioning 37
36 and 36 I am in opposite party
36 से mention करते जाएगा
36 I am for the petitioner my lord I am for through VC that case I am for the opposite party my lord 36 interim order to continue
yes
आया 36 से कौन order थिला adjournment थिला ना stay थिला
stay thira
interim order continue करियो next date जाइथिला
stage
it is there till the next date it is there it is not reached
oblige me
so that order is not being touched
my lord
ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି 26 when it should come. 18
My lord, at the convenience of my lord. After vacation also no problem.
Yes, Mr. Chaudhary. Particularly.
My lord, any date I am for petitioner, any date at the convenience of my lord.
There are the computer no ni convenience of my lord marle computer accept koni.
We commencing from 18.5.
Mr. Chaudhary, actually we could not hear you. You are disconnected. Again, but
My lord, I am not audible.
In the network problems there.
Mr. Sethi, you are audible actually. Mr. Chaudhary is not audible, also visible. Apano khali photo tanga rahi jauchi.
Milords, sir. Yes. Sorry, Milords.
After vacation date.
No, Lordship gave a short date because the Lordship I also file an IA is there.
ठीक है चौथा yes so सेटा अपन तो सुबह नथिला so सेठी 18/5 week
We oblige.
Lordship can it be before my lord?
ना shortest possible लगे ता पूर्व रे already cross 100 4-5 रे 100 cross कर सलेन so I mean reasonable possibility of reaching the matter actually.
I want
not a problem, but there should be a reasonable possibility. Hearing matter all the time lagi was.
Subject to Lordship acceptance. In this case, in fact, I want to give a proposal. Both the parties can come for a mediation. It would have been
mediation is a difficulty nahi, but apan mane raji hava darkar and possibility raheva darkar.
I am the
to talk to Mr. Sethi, no difficulty. Mr. Sahoo, कौन चाहते हैं Sethi sir?
Item 31 measure.
Much obliged, my lords.
Kindly see the last order measure. Interim order was not inadvertently was not reflected in the last order. At 11/2/26. Earlier it was not admitted. 12/2022.
Okay.
Yes, ma'am.
So a Sahoo for the petitioner.
Yes, ma'am.
The matter is mentioned as it could not reach due to paucity of time.
Yes.
That it is submitted by the counsel for the petitioner that the interim order dated
5/12/2025
needs to be extended. Stop. Accordingly, the interim order dated 5/12/2025 shall continue till the next date of hearing, list in the week commencing 18/5/2026.
Lordship, may I please your lordship? I am appearing for the opposite party. So we have no objection if they go for mediation.
देखो अरे आपण एठी थिले कोन पर आपण फोटो आसी गेले नेते आपण ना आपण क्लोन
नहीं आगे मु
एठी जेतले से फोटो रे भी से
Pardon to mention, my lord.
आपण से जो मैटर ता सेतरे मिस्टर महांती आर्ग्यू करथिले से लास्ट पार्ट ता से कहिले मिस्टर मिश्रा मेंशन whatever you have paid that will be adjusted towards the monthly dues during pendency आपण पेमेंट करछंती एठी हाई कोर्ट रे What mediation kata Mr. Sahoo?
Yes, my lord. I have no objection.
So go ahead, no difficulty.
Yes, ma'am.
Mr. It item 37, Mr. A. Sahoo.
Yes, ma'am.
Opposite, आपन power अच्छी Mr. Mahapatra.
More power नहीं on behalf of. more power to reflect in this sir.
Mr.
J.S. Samal.
A.S. Abhijit Swarup.
Jit Swarup Samal.
Mr. J.S. Samal on behalf of A.K. Mahapatra for the opposite party. Total paucity of time like it. Continue. The Lorded Counsel for the parties shall make all endeavor to arrive at a amicable settlement between the parties acceptable to both. If for referral of the matter to the Lorded Counsel have liberty to mention. What mention kale hai jibo? But upon first of all you initially work it out.
Yes, ma'am.
Yes.
Pardon to mention, my lord.
Interim order to con.
Thanks. Samal nothing is asile. But Samal ko clone, whatever. Looks like clone.
Yes.
Pachare ki jab background nahi, crazy.
And background nahi, it blurry is lordship.
Yes.
Item 26, Your Honor. The matter is on 13th of this month. Lower court. 13 तारीख है Monday ଅଛି sir
ସେଟା 27 ରୁ ତ ରହିଛି ଏବେ
sir ଟିକେ adjournment ଟା ଖାଲି ହେଇଗଲେ time petition ତାହେଲେ adjournment ଟା
କୋଉଟା
ମାନେ item 26 ଜାଣିଛି sir
ଆପଣ କହିଲା ବେଳେ ତ 27 ସେଟା 11 କୁ ଯିବା 27 ରେ actually they have already 70 ଟା ଖଣ୍ଡେ ମ୍ୟାଟର ହେଇଗଲାଣି
sir ତ ଆଗେ ରଖିବେ
ଆଉ ଥରେ ନମ୍ବରଟା କହିଲେ ଆଇଟମ ନମ୍ବରଟା
26
26
the suit is on lower court on 13th of this month Monday.
It is submitted by the learned counsel that the total line at item 27.
26.
So 26, sorry, item 26 is submitted by the learned counsel for the petitioner that the matter before the learned judge family court.
Nice. So civil suit by
The CS 222 of 2025 is posted by the learned
senior civil judge Barika.
Civil judge senior division Jaleshwar. CS number 321 of 2025.
Triple two 2025.
222 2025 is listed before the learned civil judge senior division Baripada.
No, civil judge Baripada, yes.
Civil judge senior division Baripada
District
on Mayurbhanj on
13th. On 13th.
On 13/4/2026. So it is directed upon a prayer being made before the learned civil judge senior division to adjourn the matter. It shall be posted beyond 4/5/2026 as would be convenient to the learned court in season. Well, the matter shall be posted on 27. Item 41. Yes, 41.
Yes, sir.
Date ଚାହୁଁଛନ୍ତି before vacation?
Yes, sir.
18/5 ରଖନ୍ତୁ
Adjournment petition interview adjournment petition
ଅଛି ସେଥିରେ
ଆଜ୍ଞା ଗୋଟେ possibility ସେ suggest କରୁଛନ୍ତି ଗୋଟେ settlement ପାଇଁ ହେଇଗଲା
always
yes sir
in matrimonial matters when two souls are involved any kind of settlement is good.
Yes.
You are Mr. J. Swain.
Yes, sir.
Mr. J. Swain for the petitioner. Opposite party blank. The matter could not reach during the day's proceeding due to paucity of time. Is mentioned by the learned counsel for the petitioner at the end of the day's proceeding. ଆପଣ ଅଛନ୍ତି 41?
Yes, madam.
ଆପଣଙ୍କ ନାଁ madam?
Sarmisha Naik.
Yes, it is there. Miss Sarmisha Naik for the MS Sarmisha Naik for the opposite party. S Naik ଅଛି. Kiran Raut, S Naik, SS Raut ରେ 41. Right? ଆଉ ଗୋଟେ ଲିଷ୍ଟ ଧରିଛନ୍ତି କି?
କପି ଦେଇନାହାନ୍ତି ଷ୍ଟେ ପିଟିସନ ର କପି ସର୍ଭ ହେଇନି ଆମ ଉପରେ ଆଉ ରିସିପ୍ଟ ଟା ବି ଦେଇନାହାନ୍ତି
ମିଶି ଯାଇଛି ପିଟିସନ ସାଙ୍ଗରେ ମିଶି ଯାଇଛି ନାଇଁ ତା ଉପରଟା ମୁଁ ତ ଠିକ ମାର୍କ ସେଟା ଦେଖ
ମାନେ କପି ନଟ୍ ସର୍ଭ ଅନ୍
ଜଷ୍ଟ ୱାନ୍ ସେକେଣ୍ଡ
ରିସିପ୍ଟ ବି ଦେଇନାହାନ୍ତି
ଏଇଟା କିଛି just only that order is reiterated ଆପଣଙ୍କ ଯେହେତୁ ଗୋଟେ order ଥିଲା the learned mentions likely at the end of the day's proceeding the learned counsel for the opposite party present the order dated 18/2/2026 is reiterated on a prayer being made before the learned executing court taking up ex.cr.p. number 28 of 2025 it shall be adjourned केबे कसले हो
17 April
it shall be adjourned beyond 11/5/2026 upon a prayer being made for the said purpose list in the week commencing 4/5/2026 the 4 तो already 100 पाखापाखि It shall be listed in the week commencing 11/5 पर्यंत. Adjourned beyond 18/5. Yes.
Mention, my lordship, 42 item number.
42, yes.
My lordship, the IA may be continued. IA number 5394 of 2026.
No, it is not reached. So if it is, there is no order for it. What is your name, sir?
My name is my lordship Swagat Pati.
Again?
Swagat Pati.
Swagat
Pati.
Mr. S. Pati on behalf of S.S. Bhuya for the petitioner.
To my lords, I am there for the caveators.
Mr. Ansuman Sethi for the additional standing counsel.
My lords, I am there for the caveators, your lordship.
1 and 2, Mr. Kejriwal, A. Kejriwal for the caveator.
My lords.
The matter could not reach as paucity of time intervened. The matter being in the list, the matter being in the list could not reach as paucity of time intervened. Stop. At end of the day's proceeding, the learned counsel for the petitioner mentions the matter and prays for reiteration of the order dated, the interim order dated 23/3/2026. Stop. Accordingly, it is directed the pending proceeding before the OP number 2, out of which notice number 137 dated 7/3/2026 arranges shall be listed beyond 4/5/2026. The matter shall be listed in the week commencing 27/4/2026. In the fitness of things, no further order should be passed by the opposite party number 2 in the adjourned date. Yes.